Testing one, one, two. Ha ha. Will you have an introduction?
On the next one, yeah. Oh, David will just introduce me for a minute or so. Yeah, so
I should be able to get.
he's small and I'm going to put it up here. Yeah.
One, two. Ha ha. Ha ha. Hey hey. One, two. Yeah yeah yep. Ha ha. Ha ha. Hey hey. One, two. Yep. Yeah. One, two. Ha ha. Ha ha. Hey hey hey. One, two. Yeah. One, two. Yeah yep. One, two. Ha ha. Ha ha. Hey hey. One, two. Yeah yep. Hey 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 hey. One, two. Yeah yep. Yep. One, two. Ta ta ta. One, two. How are you doing, Ben? Ben, Ben, Ben. Ben 10, 10, Ben. One, two. Um, we, Alison, we might move those chairs that's blocking it here as well. One, two. Yeah, yeah. One, two. Pop it up a bit more. One, two. Ha ha. Ha ha. Hey, hey. One, two. Yeah, yep. Ha ha. What's that? No, I put on mute on just then, seconds ago. Oh. So it's good now? A lot more firmer?
Yeah, we got heaps of headroom now.
It's really hot on that. Yeah, I know. So the next speaker is Adam. Adam's quite tall. I might.
15 to 12, 15 to 1. All right, so we'll, if Adam doesn't go over, I will have to.
I might need a water.
Yep. Go get some.
she finally got the idea. Oh, look at her. She's great. Yeah, I'm really pleased with her. So, it took a couple of years to you can put the advert out today. And successful, and he just got a bit grumpy in the end. I saw Jim, but he was yeah, he's we still on oh, that's fine. You let Brett off the hook. We didn't leave it in question. I think we should have probably made it question time. I feel sorry for him. He's got all the ideas ready to go. He just needs time to still shoot it. I was just interested in what's happening with council and stuff. Thanks.
Okay, we'll kick off again. Thank you, everyone. Our next speaker needs little introduction. He's well known to you all. Each year is the person that we're asked to ensure that we have as a speaker to present. He's been with Marsden's Law Group now for 37 years, can you believe it? An accredited specialist since 1998 in local government and planning law when the program was first introduced, and since 2021 has been considered a preeminent level in the Doyle's Guide of Lawyers. Adam Seaton.
Thanks, David. I actually stepped in the door at Marsden's this year 40 years ago as a photocopier. I was on the hill up the road at St Greg's, and somebody came up and said, "You want a job over summer?" And I've now going to be there for 40 years in December. So, welcome. I saw some of you enjoying the sun outside. My late great senior partner used to say there were two great cities in the world. One was Rome and the other was Campbelltown, and you can see today that that's clearly the case. That's why we've got so many good people here today. I was going to title my paper, "The more things change, the more they stay the same." But the reason I'm talking to you today is because things do change, and I get this gig every year to talk to you about the things that have changed in the local government, planning, environmental law sphere. And it remains one of the planning legislation, the most interfered pieces of legislation there is in New South Wales. If you go, for example, today to the New South Wales legislation website, which is where I spend most of my life, you'll see the top 5 pieces of legislation for this week. 4 of them were planning pieces of legislation. So the first one was the Education and Care Services National Regulation, the childcare regulation, childcare centres. That seems to be still one of the most popular forms of development that I'm dealing with. The Exempt and Complying Codes Development Code SEP. The one in the middle is interesting, the Crimes Act. That's the third most. The EP&A Act is the fourth, and the Housing SEP is the fifth. So out of all legislation in New South Wales, the top 5, 4 of them are the planning-related legislation. It shows you how much interest we have in New South Wales in that kind of legislation in that area of law. The topics that I wanted to deal with today, they're wide and varied. That's them on the board at the moment. All right, the first one of integrated development is interesting. You heard Brett Whitworth talk about something he did back in 1993. And that's where I wanted to start. I'm going to skip over a couple of pages to get there. Come back in a moment. But there's a quote on the board at the moment from a good friend of our firm, the Honourable Craig Knowles, back on the 15th of October 1997, the second reading speech relating to the then, what was the Environmental Planning and Assessment Amendment Bill. I came across this in preparing this paper in relation to integrated development, but that bill dealt with a number of matters, and I just want to read it to you. The Environmental Planning and Assessment Amendment Bill represents the most fundamental change to the laws associated with land use planning and assessment in New South Wales since the introduction of the Environmental Planning and Assessment Act in 1979. At that time, the creation of the Environmental Planning and Assessment Act reflected substantial community concern about the failure of the then Part 12A of the Local Government Act. I actually remember that Part 12A, I had to deal with it, to meet contemporary community standards in land use planning and assessment. Today, the same concerns are frequently expressed about the Environmental Planning and Assessment Act. Almost 20 years of legislative accretion, court precedent and administrative practice, together with the rise of other pieces of land use legislation, have created a land use and assessment regime that is long overdue for an overhaul. Everyone agrees that as a whole, the current system for assessing new developments has lots of problems. The most often stated problems with the system are that it is over-regulated, it's full of duplication, separate approval processes sometimes conflict with one another, there is a lack of certainty, there is a lack of transparency, no one is accountable, there is little coordination, the process and scale of assessment is often out of proportion to the environmental impact, and it all takes too long. Everyone has a story about some problem with state planning rules or their frustration with their local council. And it's not only developers, individual residents, builders, environmental groups, architects and ordinary people share frustrations about the lack of common sense in the system and the seemingly unnecessary layer upon layer of rules and regulations that seem to get more complex every day. We then get a quote within the Hansard from some of you may remember him, Peter Woods, who was the Mayor of Concord at the time, but he was the king of the local government association as it then was, and he was trying to fight back a little and said, delays are due to a whole range of reasons. You can't just finger the councils. We have to get input from statutory authorities and government departments. Architects are equally to blame. I could write exactly that same piece for the Hansard now 28 years later, in terms of the way that we've moved on and changes and how we've gone back in a full circle of the way in which the planning legislation works in New South Wales. That was in the context of, though, the integrated development provisions that Brett spoke about that he started working on in 1993 that came to fruition in 1997 in that piece of legislation. What I do, though, want to talk to you about is some cases that have dealt with integrated development because it's now been made even more murky than what it was at the beginning of this year. So I want to go back. So if any of you have access to the dark web, you can actually get onto the planning portal. I can't, I'm a lawyer, I can't get into it unless I create an account and do all this sort of stuff that then gives me an ability to lodge an application. So I can't even tell you at the moment what you need to do to lodge a development application because it's in the portal. You have to go into the portal to work out what you need to lodge a development application. It's not specified in any regulation other than the regulation telling you go to the portal. But I found this application form, at least. It was a hard copy document. And I've redacted the relevant parts so you can't see any of the private information about the applicant in this particular case. It has, that's part of the first page. Some of you will be familiar with the application that generates once you're on the portal when you put the information in. Second page has a section in it called related planning information, and the first question that's asked in that is the application for integrated development. That question's been around for a long time. In this particular case, you'll see the answer given on the application form was no. So what is integrated development? There's a definition in section 4.46 of the Environmental Planning and Assessment Act. Integrated development is development not being state significant development or complying development that in order for it to be carried out requires development consent and one or more of the following approvals. A pretty simple definition. You need development consent and you need one of these other approvals. You're therefore integrated development. The most common ones that we tend to deal with are probably the Roads Act, one down the bottom of the screen at the moment, where you might need to do some work on the road as part of your development. That has an exception though. If the Roads Act work needs to be done on, needs a council approval, so the Roads Act approval comes from the council, well then it can't be integrated development because it's specifically excluded from being integrated development. I'm not going to get into the whole debate about who owns roads, but generally councils own most of the roads in New South Wales other than freeways. The other two are the Rural Fires Act and the Water Management Act, where they're the most common ones that come up in terms of determining whether or not development is for integrated development. And the Water Management Act, the Rural Fires one is the Bushfire Safety Authority that you need if you're in a bushfire prone area and you're a certain category of development. And then the Water Management Act, you've got the things like the aquifer interference approvals, where if you're digging a basement, you might need to de-water or need approval to interfere with the aquifer that you're penetrating. And then you've got the controlled activity approvals that come through the Water Management Act. So they're the old rivers and foreshores improvement, 1948 Act, where you're within 40 metres of a river or an estuary and you're carrying out an activity or work within that area, you're going to need an approval, as well as many other approvals under that piece of legislation that you might need in order to facilitate or carry out your particular development. So when the bill came out that introduced this legislation, it had an explanatory note attached to it, and part of that note said, for local development, the consent authority, if it proposes to grant development consent, must obtain from each approval body the general terms of approval. Any approval proposed to be granted by it, a consent granted by the consent authority must be consistent with those general terms, and if the approval body won't grant the approval, the consent authority must refuse consent. A lot of words on the board, you don't need to read all of those, but that was what the Minister said specifically when he introduced the bill relating to integrated development. So the important parts of that is, the Minister said, when a proposed development requires development consent plus one or more approvals under certain other legislation, the new assessment process will provide that the consent authority must refer a copy of the application and any later public submissions received after exhibition to the relevant ministers and state agencies to be called approval bodies. He was quite clear on what he wanted in terms of the integrated approval legislation. It was a must, not a may or a choice that an applicant could make in relation to integrated approvals. We then get the court, though, that comes along in 2002 through Justice Lloyd in a case called Moore and Lipperoni. Now, the court takes a little different approach to what I think the Minister intended would happen with integrated development. It was a case up in Woy Woy Bay for a dwelling house that had been granted by the then Gosford City Council, and it was a challenge to the validity of that consent. One of the challenges in that case was to whether the council had power to grant consent in circumstances where it hadn't referred the matter off as integrated development to the relevant integrated approval body. In that case, it was a Rivers and Foreshores Act improvement approval that was needed because the development was within 40 metres of a particular river that was relevant for the purposes of that application. So the argument that the applicant took in that case was, well, this fell within the definition of integrated development, you didn't refer it, therefore there was no power to grant the approval for the dwelling house in that particular case. When Justice Lloyd came to deal with the case, he recognised in that paragraph 83 that the provisions of that part that had been inserted in relation to integrated development in the Act were intended to be beneficial and facultative. They're words used a lot when the court wants to tell you that the applicant should get the benefit of the doubt in relation to the way the provisions work. And that's what he said in this particular case. We're going to construe these provisions very broadly to benefit the applicant, because that's what it's all about. This legislation is to help an applicant get an approval that's consistent, a development consent that's consistent with all other approvals that might be necessary in order to carry out the development, so we don't duplicate processes that, in terms of getting the other approvals that might be required subsequent to getting the development consent. And we all talk to each other in terms of getting that particular consent. So the judge describes it as beneficial and facultative, but he then gets to paragraph 84 of the judgment, which is the crux of his judgment. He says, in making the development application, Mr. Lipperoni did not tick the box in the application form to indicate that consent was being sought for an integrated development approval. In doing so, he elected to have his development application processed as if it were not an application for integrated development. That was his choice. There was and is no compulsion on an applicant to make an application for an integrated development approval if he or she chooses not to do so. So Justice Lloyd was saying it's up to an applicant to choose whether or not you are integrated development, despite the definition in the Act that tells you what integrated development is. There is no provision in the EPNA Act says that it's an election or you may do this. It just defines integrated development. But he gave it this broad interpretation to the legislation, looking at it more holistically in his view, to say, well, the intention of the legislation is for applicants to benefit from the consistency of approvals that we're going to get, if they could get. And if they don't want to do that, that's up to them. They can take the risk that they get an approval and they'll still need to go and get other approvals that are inconsistent, and then they'll have to come back and modify their development consent to make the development work ultimately. And that case of Marsden Lipperoni has been followed for many, many years since 2002, until what I'll say is a couple of months ago, where it's been called into question in another case, and it's another case involving Gosford, of all places, and it is a case called Artmaid and Central Coast Council. It was a development application for a childcare centre for 70 kids, and there was only one contention that was left in the proceedings. It was a decision that was appealed, and ultimately all the merit matters were resolved, but the matter that was left in contention was whether the appeal had been commenced too early. Therefore, the court did not have jurisdiction to deal with the actual appeal. You might say, well, how does that raise the question of integrated development? Or, well, your deemed refusal period for a development application depends upon the kind of development application that you have lodged. So if you lodge an integrated development application, you've got 60 days usually from the date of lodgement, after which it's deemed to be refused, provided the clock hasn't been stopped in some way. 60 days from the date of lodgement, it's a deemed refusal. You then have an appeal right to the Land and Environment Court. In respect of other applications, put aside designated development and some of the other more specific kinds of applications, generally other development, 40 days after you lodge the application, the deemed refusal period arises. In this particular Artmaid case, the applicant hadn't ticked the box, even though it was going to need an aquifer interference approval, hadn't ticked the box for the development to be for integrated development, and they lodged their appeal on the 41st day after it had been lodged, the development application had been lodged with the council. So if it truly was a development for integrated development, a development application for integrated development, they had to wait at least 60 days to lodge their appeal, otherwise the court had no jurisdiction to deal with it because the appeal was commenced too early. So that was the argument that was left in this particular case. And Commissioner Dixon, who comes from up in that area, the Gosford area, she had to deal with the matter, and it was an interesting approach that she took. She was encouraged by the council, the applicant in that case, to follow the existing case law of Marsden Lipperoni and say, well, it's up to the applicant to choose, and we didn't choose in this case, therefore it's not integrated development. So that was the applicant's argument, just follow what the case law has been for years and years and years. The council, on the other hand, said, no, just read the legislation, just read the words. And that's what she did. In the end, she read the words in the Act itself that I've just taken you to that define integrated development, and she came to the view that's up on the screen at the moment, that whilst the development application form includes an option for an applicant to nominate that their development is integrated, in my view, this does not subvert the effect of Division 4.8, which is the integrated development provision. In evaluating the development application under Section 4.15, a consent authority is required to take into consideration such of the following matters as are of relevance to the development, the subject of the application. In this case, one of those matters is the application of 4.46, which is the integrated development definition, and a determination of whether the development application falls within the ambit of integrated development as defined by 4.461 of the EP&A Act. And then she found that development was for integrated development and that the appeal was therefore lodged too early and she had no jurisdiction to deal with it. Ultimately, the matter was cured. She made that judgment, said it's integrated development, I can't deal with it on the current, in terms of the current application that's before the court. Ultimately, the parties came back to the court a month or a couple of months later and made an application under the Uniform Civil Procedure Rules to have the application that had been made to the court amended to treat it as if it had been lodged on the 61st day rather than the 41st day. And that was able to be done because both parties agreed to that being done, because the matter ultimately on its merits was an application that was worthy of approval. All they needed to do was lodge another appeal and they could have got the same result, so it was inefficient to do it that way, so they actually came to a practical result. But this case now calls into question the whole concept of whether you can choose to have your development treated as integrated development, or whether, if it is integrated development, it just is. You can't choose or tick the box. You have to tick the box if it falls within one of those particular categories. So at the moment, it's only a commissioner decision. When I say only, this commissioner has some legal background as well, but it's something that will probably have to go further and be determined by a judge of the court to give us some more guidance on how applications should be treated. But from a council perspective, you need to understand this. From a developer perspective as well, how are you going to frame your application when you're putting it into the council, and take that matter on board. The next thing I want to deal with is, some of you might see in your local environmental plans that apply, whether you're a council, whether you're a developer or applicant, that there is an essential services provision. A lot of LEPs have it, some don't, and they're not all worded identically. The one I've got on the board is just an example of one that was in a case. This is the one out of the Georges River local environmental plan, because it's the case I want to talk to you about in a moment. But you'll see that this is what they call a condition precedent type of condition, or a matter that you need to be, as a consent authority, satisfied about and form a positive opinion of satisfaction about in order to have the power to in fact determine a development application. So in the wording of this particular clause, the consent authority has to be satisfied that any of the services that are listed there from A to F, if they are services that are essential for the development, that they are either available at the time of determining the development application, or that adequate arrangements have been made to make them available when required for the particular development. There was a case recently that involved this parcel of land here. So what was proposed was to develop this number 12 here for a dual occupancy development. There was going to be a dual lock on pretty close to where that existing building is, so that was being demolished, dual lock there. Then there was going to be a subdivision and another secondary dwelling or dual lock in this area here. That secondary dwelling had to get access through here, David Place. See that little strip of land there? That's what the council called a development control lot. We used to call them grudge strips. So the council had created this little lot which it owned because it had funded the building of this road. And it wanted to get some of that money back eventually from anybody who wanted access into these parcels here for the purposes of their development. So that's why that little lot there exists in this particular subdivision. We try not to do that nowadays, but it wasn't a bad device back in the old days. So this application gets put in, gets refused by the council on the basis that there's no legal access to this lot in here. In the meantime, so that application gets refused, the applicant appeals against that, and in the meantime starts another proceeding in the court against the council, seeking what they call, it's a Section 40 application, which is similar to what is called a Section 88K application, to compulsorily obtain a right over that council strip of land to access that rear parcel. So they'd started that separately, but it hadn't been concluded and it was still ongoing in the court process. And Commissioner Gray had to deal with this particular application. She came to the conclusion that she could deal with the development application and that, I'll just go back to, and this essential services provision, which, as you see at the bottom, you need to be satisfied as the consent authority that suitable vehicular access is available. It wasn't available at the time, so you can't meet that test. So she came to the conclusion that adequate arrangements have been made to make the suitable vehicular access available when it was required, by the fact that the applicant had an ability at least to physically go across that land in a reasonable way, not legally yet, but physically that was an appropriate way to access the land. She said there was a process already in place to obtain the legal right or entitlement. That was the separate proceeding to compulsorily get that legal right or entitlement through the courts. That the council had not identified a legal impediment to the grant of easement. So if that process was followed through, the court could grant an easement over that land. It wasn't community land, it was just operational land of the council. And that the development consent could be granted for Lot 8 with no issue of owner's consent. So that's one of the interesting things in relation to a development that involves council land. The court stands in the shoes of the council for the purpose of giving owner's consent. So the council couldn't deny or reject that application on the basis that there was no owner's consent over Lot 8, because the court gives that owner's consent if it in fact determines the application by way of approval standing in the shoes of the council. And the fifth thing that the Commissioner caused her to be satisfied was that the deferred commencement condition could be imposed until an easement was obtained. So what she did was grant development consent to that dual occupancy and subdivision with a deferred commencement condition that said this consent can't operate until you actually get the easement from the council over the land. Whether you get it through the compulsory process, through the court proceedings or in some other way, it didn't really matter. But as long as you get it, your consent can then become operational. But if you don't get it, your consent won't be operational. And that's been something that's been employed by councils for a long time, that kind of deferred commencement approach, where you're satisfied that there's at least a potential for being able to get an easement over land. It might be for stormwater. That's the most common one that we see, where you need to put stormwater through an adjoining property. You don't have a right yet, but there's some process in train, and it's a legal and feasible and reasonable way of draining stormwater. In this case, vehicular access was the issue. But we've been using that tool for a long way just to avoid having to deal with this provision. So this matter, the council loses, and it appeals to a judge of the court, and Justice Robson is the judge appointed to hear the matter, and he says, no, Commissioner, you got it wrong. You can't form the opinion of satisfaction that adequate arrangements adequate arrangements have been made, because there's still an ongoing process in relation to that, and we don't know the outcome of it. We don't know that the court's actually going to give an access or vehicular access easement or right over that land. So you had no ability to come to the conclusion that you were satisfied of the matter in that essential services provision, that there had been adequate arrangements made. So what the judge said of importance is that in the first paragraph, it's basically said, if there's access available, well, then you meet the test, no problem. But if the access isn't available, the second paragraph, he says, I find that the state of satisfaction thereby requires consideration at a different moment in time, such that the adequate arrangements must have been made. That is, there must be a current arrangement that has been made. That arrangement is that the essential service, here, suitable vehicle access, be available when required. That is, in the future. Put another way, the service that is not presently available will be available, and it will be available because adequate arrangements have been made to make it available. You go around in circles, but that's where he gets to. But he says, further, while it is clear that something less than a formal or binding promise is required, I find that there must be some form of objective and tangible proof to constitute an arrangement as something made. So in this case, the council was objecting to giving the easement. There was no arrangement whatsoever for the easement over the land to be created, and you couldn't even get to the point saying that there was at least some tangible proof to constitute an arrangement between the parties, and therefore the Commissioner was found to be in error in just imposing a deferred commencement condition to put that matter off until later for the arrangement to be made between the council and the applicant to enable the consent to become operative. So that's a caution in relation to both applicants and developers as to what you need to get all your ducks in a row before you seeking either approval through the council or the court to at least get to the point where there is proof that your neighbour or whoever it is that owns land that you need to use for the purposes of your development or facilitate your development is on board to give you that, or you've gone through the process of obtaining through either Section 88K of the Conveyancing Act or Section 40 of the Land and Environment Court Act, the relevant easement that might be necessary to facilitate the development. All right. Next case. I often end up in cases where I've got developers who are wanting to be quite generous and hand over land to the council. So you might be doing a subdivision and there's a part of the subdivision that might be proposed to be handed to the council as a public park, or it might be some other environmental corridor that is proposed to be handed to the council. Years ago, council said, yeah, give it to us. We want this land. We want to keep all this land. And more recently, council say, we don't want that land. We don't want the burden of it. We don't want the financial burden of maintaining it. You keep it, developer. We don't want it. And that's what this case concerns. There's a case, and I think I've got Matt Stewart here, so concerned this bit of land next to Peace Park. And you'll see there was what was proposed here was you'll see a long battle axe type of handle into a lot that was proposed to be subdivided in that way. So I'll just go back to it there. That's the land. So there's a battle axe handle that continues up the page. This doesn't contain the whole of the battle axe handle, but it continues up the page and onto the road. But it was in essence what is a subdivision into some, it was a community title subdivision into some residential lots, with lot 1 being the community property. So that was the road coming off King Street into the lots. And then it was proposed that lot 9 be dedicated to the council to adjoin Peace Park, which if you go back there, you'll see that Peace Park is right next to it. So the developer didn't want that land. They said it'd be a good idea if council took it and incorporated it as part of the park. There was a little note that I've got in red circled up there that was on this particular plan of subdivision. If you can't read it, what that note says is it is intended to dedicate Lot 9 to the public as public reserve in accordance with Section 49 of the Local Government Act 1993. And what Section 49 says, it's really only paragraph 1 of 49 that's relevant, that it says on the registration by the Registrar General of a plan on which land is marked with the words public reserve or a transfer or conveyance to council of land identified, that land is dedicated as a public reserve and vests in the council as an estate in fee simple. So in essence, if you have a notation on a plan of subdivision that says a certain land is, or lot within the subdivision is to be dedicated as public reserve, Section 49 of the Local Government Act will operate once the plan is registered to give it to the council. It happens automatically once the plan is lodged at the Registrar General's office. What the applicant said in this particular case was that the best use of that, what I'll call the handle, that lot 9, was for it to be incorporated with Peace Park, and that council should accept it and assume responsibility for the maintenance of it. And they referred to a case that was an interesting case I'll come to later as well, of Justice Preston of Gold Coral and Richmond Valley Council, where in that particular case there was a similar circumstance where the council was opposing the handing over of a piece of land to be as public park from the developer to the council. And you'll see what is on a said about that in the Gold Coral case. He says the council also opposed the dedication of lot 147, which was the proposed park. And he says its reason was tenuous. the council said it does not have the financial, human and material resources to manage and maintain the local open space and parks which it currently has, and is considering disposing of the existing parks. In these circumstances, the council submitted it cannot accept and manage an additional local park. I reject this reason. He then says at 177, and this is really important, I don't know whether he's in the real world, but with respect to the Chief Judge, the management of local public parks is a fundamental responsibility of local government. If the council is not coping with the management of existing public parks, it needs to improve its performance. Discriminating against the residents of one neighbourhood, the residents of the proposed residential estate on the land, by not accepting and managing a local park for those residents is not equitable. Gold Coral will establish all of the facilities in the landscape in the park before dedicating it to the council. The council only has to maintain the park afterwards. Some of you, I heard the groans in the room, would see where that is not something that is, councils nowadays, the limited resources they have, this is a real problem. It's not just 2 paragraphs of a judgment throwing it away. And what I'm saying is if you're a responsible applicant or developer, yes, you are building the park, but you're also, if you're going to hand it to the council, making some financial accommodation in relation to its maintenance as well for an ongoing period, because that park forms part of your development ultimately, and you want to make it look good and keep it looking good for a period of time. So generally you can sort those things out, but where you just want to hand something over and give the council the burden, well then the Chief Judge thinks that that is okay. So that judgment gets applied in this Canterbury Bankstown case, where what happened was that the commissioner who was dealing with the matter, you can see what she said, that the respondent has given no compelling or credible reason for not accepting the dedication of Lot 9, so that's the public park lot. And I agree with the respondent that it would not be in the public interest for Lot 9 to be retained in the private ownership of the applicant. I agree with the applicant that it is practical and logical that the strip be added to the park. And so Justice Preston had to deal with this on appeal, and what do you think he did? He followed his earlier decision in the Gold Coral matter and came to a conclusion in a little different way, because it was argued by the council in this case that the court had no power to require a council to take land that it didn't want. He said, I'm not doing that, or the commissioner didn't do that in this case. All it did was approve a development for a subdivision. That plan of subdivision happened to have a notation on it that is given effect not through the planning legislation, but through the Local Government Act, which I'm not dealing with. So I'm not offending the general principles that would say councils can only require dedication of land free of cost if it's in your contributions plan and it's in accordance with section 7.11, or it's by way of a planning agreement. So they are legitimate ways which councils can get land or have land dedicated to them, and in fact they are the only ways under the planning legislation you can do it. But this way, where the notation is put onto the plan, it's not a decision being made under the planning legislation in relation to the development, it's simply a notation that is given effect through other legislation, in this case the Local Government Act section 49, so is not offending that principle of imposing a condition that is not authorised by the Environmental Planning and Assessment Act. So that's the way he rationalised the decision, on the basis that he wasn't going to take the Commissioner wasn't going to take the notation off, he wasn't requiring the notation to be taken off, it wasn't offending any of the provisions of the planning legislation, and it would operate in a, it would operate for itself later on when the plan of subdivision came to be registered. So that's the prevailing state of the law at the moment, and both applicants and councils need to understand that and take that into account when, particularly in relation to large subdivisions where these kinds of offers are being made to provide land. It's also in the context of roads. So under the Roads Act, there's a similar provision that if there's a notation included on the plan that says these particular areas are to be dedicated as roads under Section 9 of the Roads Act, that provision will operate independently of any planning legislation for the roads to in fact be or come across to the council when the plan is registered. That particular issue is becoming more and more tricky though, because it's long been accepted by developers that you dedicate roads as part of your subdivision where they are to facilitate access to your land. You don't want them, you want the council to maintain them unless you're doing a community title subdivision. But we've had a number of recent cases where roads are shown in development control plans that don't necessarily need to be built in order to facilitate development to a particular lot, even though they might adjoin that lot, and the developer says, well, don't care what your DCP says, we're not going to give you that road, nor are we going to build it, because you haven't got a contributions plan that provides for it, nor are you ever going to get one that's going to include roads of that kind. And you can pay us for the road and you can pay us to build it. Or you can come and compulsorily acquire it from us. So there's a little hiatus between, at the moment, as to DCP, great idea, but it's only a guideline. It can't force a developer to give a road, or in fact give a road free of cost, unless a voluntary planning agreement is entered into, because it won't be in your contributions plans. All right. Some of you might have seen this little building. Oh, where's Brett Daintree? Is he here? He was here before. Yeah, do you know that building, Brett? Yeah, okay. I wasn't involved in this case, but I think Brett has been for many, many years. It was reported in the Sydney Morning Herald a couple of weeks ago, the Molass building. Some of you may have seen the article or the investigation by the Herald reporter relating to building information certificates and the frustration that councils have when developers or applicants or landowners don't do the right thing and they don't comply with their development consents and they dig bigger basements than what they're supposed to, and then come back and seek a building information certificate for the basement or for other works they've done that don't comply with the consent that was carefully crafted by the consent authority, or to try and avoid things like that happening in the first place. So this is the Molass building that is, as you can see, up and running and occupied by the owner of the site, Mrs. Molass. The site had a very long history. It was an application that was made back in 2017 for a two-storey dwelling and a swimming pool and some basement car parking out in Bowden Avenue in Strathfield. And it got consent, but in 2020 there was a development control order, a stop work order issued in relation to the development because the works weren't being carried out in accordance with the consent. And then between 2020 and 21, Mrs. Molass lodged an appeal against that order, and also she made an application for a building information certificate and a development application to use the land and to make further alterations and additions to modify the approved dwelling that consent had been granted for in 2017. That development application was refused by the Senior Commissioner of the Court, together with the appeal against the stop work order and the appeal against the building information certificate. So the Commissioner dismissed everything and said, you're not getting what you want in this particular case. And the reason the development application was refused by the Commissioner, you can see on the screen at the moment, there was a 4.6 request that was made to contravene the floor space ratio development standard. You'll see I've highlighted Mr. Daintree there in the middle of it, but Mr. Daintree's evidence was accepted, so he must have done a good job in that particular case. But you'll see the reason that it was refused, the proposal exceeds the permissible GFA by 68 square metres, or 15.6%. The breach of the standard has adverse environmental consequences for the whole of the development, and it's incorrect to submit that the exceedance is confined to the basement level. As I observed and Mr. Daintree identified in his evidence, the basement story is visible from the street and adds to the bulk and scale of the development. A third story is inconsistent with the surrounding built form existing and new. The built form cannot be described as being consistent with the objectives of the standard. Although allowing the contravention does not, as the applicant submits, enable the proposed development to achieve important planning goals. And at 57, the Commissioner said, put simply, the environmental planning grounds relied upon by the applicant in her clause 4.6 written request do no more than to seek to promote the benefits of carrying out the development as a whole and don't justify the 68 square metre exceedance that of the control that was evident in the development. So Mrs. Malatz gets this refusal of all applications that she's made. Then she makes a new development application in January 2024 for partial demolition of the existing dwelling and some alterations and additions which she describes as responsive to previous litigation, including associated landscaping on the site. That's the description of the development in the development application form. That DA goes to the planning panel says no, and then there's an appeal lodged with the court. And then there's this decision, which is a preliminary decision relating to the application because the council sought to strike the application out from the court on the basis that it was an abusive process because the application proposed had very little differences to the application that had been refused by Commissioner Dixon a few years ago, back in 2002. So the council argued that this matter shouldn't be allowed to proceed in the court because it was virtually the same as the DA was refused. There was a slight change to some articulation on the first floor. There was no new or factual or statutory change in circumstances. That the clause 4.6 request that was made was almost identical to the one that had been dealt with before. That the 2022 application that had been made dealt with by the court had been amended 10 times before it even got to court at a final hearing in that particular case, and that the council would be severely prejudiced if it had to deal with this application again, prejudiced presumably in terms of costs being incurred in relation to the appeal. The council did accept that anybody can make multiple applications, so at a council level, when the application comes in, if it's for exactly the same development that's been refused a week ago, you still have to deal with it and you'll probably refuse it again. Court is a little different. Once you get to court, there is this concept of abusive process that if you're continually litigating something that is already or has already been dealt with by the court, well then that's not an efficient or proper use of the court's resources and you shouldn't be allowed to do that. But trying to prove abusive process is quite a high hurdle. Because the court is very reluctant to shut somebody out completely if there is some change to what case they're seeking to bring in different circumstances. So in this particular case, again, not all the words are important on this page, but the principles relating to abusive process and when a council can argue that an application shouldn't be allowed to proceed in the court was set out a few years ago by Justice Davies in the Court of Appeal in a matter of Cogger and Russo. And what Justice Davies says is it's an abusive process for an applicant to bring repeated applications to a court, such as the Land and Environment Court, seeking to re-agitate issues which have, as a matter of substance, already been determined in prior decisions. So that's a general principle. And at 15, he says the application of this principle is not precluded by the making of some minor changes to a town planning application or by reliance upon an argument or arguments which could have been put but were not previously put. If there has been no significant change in circumstances, the new application ought not to be brought. Otherwise, the application will appear to be a collateral attack upon the prior decision or decisions of the court. Justice Payne was asked to deal with this motion to strike out the proceedings, and she came to the conclusion ultimately that she wasn't convinced that it was an abusive process in this particular circumstances, and there were a couple of reasons that she relied upon. Firstly, she noted that the changes or physical differences between the two DAs, the 2022 one that had been dealt with by the court, or the 2021 that had been dealt with in 2022, and the new DA were qualitatively minor, so the little difference in the numbers that were being dealt with in terms of the changes. But she said, I accept there are relevant differences in the development proposed from that in the 2022 application, and the parties disagree on whether those changes are qualitatively different for the streetscape and the neighbours, that will be subject of expert opinion in this particular case. So that seems to be the reason in this case why she came to the conclusion, I can't throw this out on an abusive process, because there was still an argument to be had about whether those changes were in some way changing the application sufficiently to make it one that had differences in the streetscape and for neighbours. So she gets to the point in this case at the last paragraph. There's also other arguments raised by the council, the fact they'd had to deal with a previous application that got amended 10 times. She said that's not relevant to an abusive process in terms of the new application. She also said the fact that council had other class 4 proceedings, so injunction type proceedings and other remedial action on in the other parts of the jurisdiction of the court, that wasn't relevant to an abusive process. So really she focused upon the fact that there were changes in the application that were sufficient to put it on the side of the line that meant that, that this particular appeal was not an abusive process, and that's the conclusion she came to on the last paragraph, paragraph 47. But this is an area that is really standing out for reform. Council's resources, time, financial burden in dealing with applicants who don't do the right thing, whereas most people try to do the right thing, and how that might be reformed is something that I think the government to look at to try and at least have a process that is not going to end up in these kinds of proceedings where this one been going now since 2017. All right, who knows where those words are from? Yeah, there you go, Rolling Stones. Some of these judgments of the court, they're getting a bit carried away with some of the quotations. This is Commissioner Walsh, and he was dealing with the zone objective in the R2 zone. Some of you will be familiar with that particular objective of the zone. It's a common objective to all R2 zones. It's one of the mandatory objectives that come out of the standard instrument, and it's the matter that was subject of this case at Billiard Avenue in Elizabeth Bay in Sydney that I want to talk to you about in the context of that particular little Rolling Stones quote. So this was a case, it's an important case for two reasons. One is the Chief Judge gives some guidance on interpreting zone objectives when it comes to looking at in this case it was the R2 zone he was looking at, the low density zone. And it's also important in the context of how cases might be managed by councils where they've reached an agreement or are generally happy with a development in the context of court proceedings. So what this case involved, that site there in Elizabeth Bay, it had 2 street frontages, and that was a building that had 28 units. So the total building there was 2 components to it, but it had 28 units in it with a total of 48 bedrooms, and it had predominantly 1-bedroom units in it. So 16 one-bedders, 4 2-beds, and 8 3-beds. That was the mix in that development. The developer comes along and wants to do this, so knock down everything on that site. Not, in terms of form, there's a lower building and there's a higher building, but this development was for a lesser number of units. So 20 units is proposed on this site. And you wonder why, because they have views to the water, probably one of the reasons why they wanted to reduce the number of units and make them, in fact, bigger. So you get 20 units with 2 2-bedders, and the rest of them were 3-bedroom units, so 18 3-bedroom units in this particular development. No 1-bedroom units in it at all. But more bedrooms. So the original development only had 48 bedrooms. This had 58 bedrooms, but less units. So this ends up in an appeal before the Commissioner, Commissioner Walsh, and all of the issues get resolved between the council and the applicant, not any issues left whatsoever. They then enter into a document called a consent order document, which is where the council and the applicant have agreed to certain orders being made, not a conciliated agreement, but a consent order where they say council and the applicant agree on this development application being approved subject to conditions. Consent orders are dealt with differently to conciliated agreements. So there's a regime in the Land and Environment Court where if you have a conciliation conference and you enter into a conciliated agreement, the court is required to make and is forced to make orders in accordance with that particular agreement if it's satisfied that it's lawful to do so. So it has to be satisfied of conditions precedent and jurisdictional matters. So, for example, that provision I had on the screen a moment ago, the 6.9 provision about essential services, that's a condition precedent. The court has to be independently satisfied of that matter. There are other matters it doesn't need to be satisfied about, they're just considerations. So the court doesn't care about that. So years ago, Tim Moore, who was here last year, said a commissioner is bound to sign off on a particular development, a conciliation, even though it mightn't like the smell of the development, it might hold its nose and sign the conciliated agreement and approve that anyway, because it's not concerned with the merits of the application, only whether it's lawful to be made. Before we had conciliated agreements, the only ability for parties to agree was to enter into consent orders. That option is still available. But if you enter into consent orders, the court's role is different. It has to consider not only whether it's lawful, but whether it's appropriate to approve the development. So that involves a consideration of the merit matters in the context of a development application that is being put before the court by way of consent orders. So in this particular case, the Commissioner said, thanks very much for those consent orders. I know you both agreed, and went away and then came back with a judgment a little while later and said, I'm not happy. I'm not going to approve this development, even though both you, the council, and you, the applicant, are happy with it. I'm not happy. And I'm not happy because, in my view, it doesn't meet the first objective of the R2 zone, which is to provide for the housing needs of the community. What you're doing here is you're reducing the number of affordable apartments that are available and reducing the overall yield of the development and replacing it with some luxury kind of development that means that the needs of the community aren't being met. What he failed to, in the Chief Judge's opinion, to do was to properly interpret those words of to provide for the housing needs of the community. Where does it say anywhere there it's about particular parts of the community, or it's about affordable housing, or it's about anything else other than the community, which is the community at large? And that's where the Chief Judge criticised him heavily in this particular judgment because experts were saying, well, look, it's removing affordable housing, it's reducing the number of units that are available to so how can it be meeting the needs of the community? He went through dictionary definitions and he isolated each word in that particular phrase to provide for the housing needs of the community. And the Chief Judge said, that's wrong, you don't even do that. So he said, and he relied upon the evidence of experts to tell him what he should think about the interpretation of the provision. That's wrong. As that quote on the board says at the screen says at the moment, statutory interpretation is not a matter of evidence, but rather a question of law applying settled principles of statutory interpretation. So experts can't tell you what a provision means. The person who's making the decision, in some cases the council or the other consent authority, in this case the court, you have to look at the words and interpret those words for yourself, applying proper principles of interpretation. And that comes out of an old case that also related to something in Elizabeth Bay. It was a decision of the Court of Appeal in New South Wales where Judge Leeming says, speaks for itself, that the words in a sentence are not building blocks whose meaning is unaffected by the rest of the sentence. The sentence is the unit of communication by which language works, and the significance of individual words is affected by other words and the syntax of the whole sentence. Does that help you? We like this stuff, you know. And then read this one. This is even better. So this is the Chief Judge who says at paragraph 59. The Commissioner misconstrued the phrase "the housing needs of the community" by focusing on the words in isolation and without regard to syntax. The Commissioner failed to appreciate that the term housing qualifies the term needs and is preceded by a definite article, the, which all indicate that the term should be construed as a composite expression, the housing needs, whose meaning is different from the sum of its parts. The use of the word "of" indicates the relevant housing needs are those belonging to the community. The community is necessarily made up of diverse people. The reference is to the community as a whole and not just to some subset of the community, such as socio-economically disadvantaged people. The housing needs of the community are thus those belonging to the community as a whole and not some subset, such as those in the community who are in need or with limited access to housing stock. He's probably got the interpretation he's got is right. The words he uses are complicated to get to that particular point. But he put Commissioner Walsh back in his place and said, no, look at the whole of the words, interpret that sentence in its context. Don't just pick out words from there and try and give them all individual meanings and then come to a conclusion on what that means. So that interpretation of that provision is important because that's a general objective that's in all R2 zones. That's not a provision that's concerned with affordable housing at all. The next part of the case is important for councils in terms of what I spoke about at the moment, where councils, a moment ago, when a council does come to an agreement or is satisfied in a court proceeding that a development should or capable of being approved because all of the issues have been resolved through amendments or whatever it might be, then the Chief Judge recognised that there were things that could have been done in this particular case other than putting consent orders to the court. So this particular case, it was still a deemed refusal. So the council could have determined it itself if it thought it was okay. It still had that ability to do it. It hadn't actually determined the application, even though it was on appeal. So it could have done that, or it could have requested the court to arrange another conciliation conference and enter an agreement in the form of a conciliated agreement, which means that the Commissioner wouldn't have been able in that case to delve into those matters of merit, like the consideration of the object of the particular zone in that case. But he said the court cannot order the council to pursue either of these courses, which would implement the parties' agreement reflected in the consent orders. But if the council chooses not to take either of these courses and puts Billiard and the court to the cost of conducting a further hearing of the appeal against the council's deemed refusal of the development application, in circumstances where there still remains no contested issue that development consent should be refused, the council's conduct can be taken into account in deciding whether it's fair and reasonable to make a costs order against the council. So he's encouraging the council to take a different approach and resolve it in a more efficient way than providing consent orders again. Ultimately, what happened in this case is the council referred it back to its local planning panel and it got approved. That's where it all ended up because the council was happy with the development. So this is another. So then the Chief Judge gets into quoting from T.S. Eliot in this particular case: "Between the idea and the reality, between the motion and the act, falls the shadow." So this takes me back to the gold coral case, the one that I quoted from earlier in the context of the land subdivision and the handing over of land to the council. So the judge got good inspiration for his decision in this case from the poem The Hollow Men. And it relates to a site that has been controversial for many, many years up in Evans Head. It's involved, some of you might recall it, but it was on Iron Gates Drive where there'd been a lot of illegal development done, unauthorised development over many years. And the site, it's the right-hand, the site is the whole of the yellow, but it's really the right-hand portion of the lot that was relevant for the purpose of this particular application. So you'll see I've got a red circle on the screen. That's an area that's identified as being coastal wetlands on this site under the Resilience and Hazards State Environmental Planning Policy. The development that was proposed as part of this application that the Chief Judge was dealing with, and you can see on that site there had been a lot of clearing that had happened down here in the past, and other works that had happened on this land. There'd been, along this Iron Gates Drive, there'd been all sorts of works done to try and get this land to a point where it should be capable of being developed. But it had been identified as a parcel that had zonings on it that allowed subdivision and development of it for many years. The development that was proposed in this case was that over, and that's sort of, it's only in this portion here where the subdivision's occurring. Down there, the rest of it gets left as a residue lot. So you'll see there's an area in the middle of the subdivision that's literal rainforest, that's left alone, so that's managed as part of this development. It was a concept development application with a stage 1 attached to it for a number of, I think it was 100 or odd so lots. But you'll see where I put the red again up there. If I go back, that's approximately where that red is on there. So the applicant wasn't subdividing, adding a separate lot in that area. It was just part of the residue lot that was in the subdivision development application. The issue, there's an issue I want to get to in this case, but I just want to go to some good words from the judge, again in the context of his poem. So there was a number of respondents in this case. There was the council, there was a member of the local Indigenous community, and then there was another community group, I think. But the judge says the council's, Ms. Barker's and the community's opposition are founded on ideas about the development proposed in the amended development application, the environment affected by the development and the law applicable to assessing the development application, which are not reflective of the reality of the development, the environment and the law. Thus, my reference to T.S. Eliot's observation that there's a shadow between the idea and the reality. The shadow may be dispersed by shining a light to illuminate the reality of the development, the environment and the law. Let me explain. He goes on, the idea of the development is founded and framed by the excessive and allegedly unlawful developments carried out on land by the previous landowners, as well as the more extensive and less environmentally sensitive development originally proposed by Gold Coral in the development application first lodged in 2014. Those developments and their perceived unacceptable environmental impacts are seared in the memory of the council, Ms. Barker and the community. Then he gets to it at 7. The reality is that none of those developments is now being proposed by Gold Coral. Gold Coral has amended the development application to propose a residential subdivision that is less extensive and confined to areas of the land that have been previously cleared and many times over many decades so as to avoid significant impact on environmentally and culturally sensitive areas of the land. So what he was saying in that case was, yes, there was lots of bad stuff that happened in the past in relation to this site, but this applicant has come with a proposal that is completely different to what has happened in the past and is seeking to do a development that is much more sensitive than anything that was proposed to be done or was done in the past, either unauthorised or otherwise. This case, though, is relevant in a more legal and technical sense in terms of a provision I did speak briefly about last year, and that was a provision that is in the hazards SEP, sorry, the resilience and hazards SEP. It's a clause 2.7 that's in essence provides that development for which consent is required other than development for the purpose of environmental protection works is declared to be designated development for the purposes of the Act. So it's a provision that applies to land that is affected by the coastal wetlands and littoral rainforests mapping, which this land was affected by. So if I just take you back to that map, that blue is where the land is affected by the coastal wetlands on the mapping. So this clause applies to, in essence, in its second subsection, development for which consent is required by subsection 1 other than development for the purpose of environmental protection works is declared to be designated development for the purposes of the Act. So the council was arguing in this case that this was designated development because this was other work, any other development, so that's the provision on the screen at the moment, it was any other development that was being carried out on land identified as coastal wetlands. But you need to read those words carefully. It says the following may be carried out on land identified as coastal wetlands, on the coastal wetlands and littoral rainforest area map only with development consent. And then it says the carrying out of any of the following, it has a list of things, and then at D, it says any other development. So if you are any other development that's not listed there already, you should be designated development for the purposes of the clause. So the council says that's the case. The subdivision is other development, and therefore the development's on land, that is coastal wetlands mapped, therefore you're caught by the provision. Chief Judge doesn't agree. He says in this particular case that the subdivision itself, first of all, wasn't dividing where the coastal wetlands land was. It left that area as part of a residue lot, so therefore there wasn't actually a subdivision occurring of that part of the land. That's the first paragraph on the screen at the moment. So that was one of his conclusions. It remained, that area that was the coastal wetlands in that little red circle that I had remained intact, not divided. He then went on to say that also, although subdivision of land is development as defined in the Act, the mere subdivision of land by the procuring in the registration of the Office of the Registrar General of a plan of subdivision without undertaking any physical work doesn't involve the carrying out of development on land. So that provision, as you can see, is about carrying out development on land, which is in the first paragraph. The following may be carried out on land. He says subdivision without any physical works being carried out is development of land, not on land. So therefore, subdivision is not captured by this particular provision, and therefore the development was not designated development. So a very fine distinction, and it shows you how words are important in the context of these provisions that Parliamentary Council drafted, even though they may have had an intention that subdivision was caught, because they didn't specifically exclude it. The judge makes a very fine distinction between subdivision being, you subdivide, when you're subdividing something, you're doing a subdivision of land, you're not doing a subdivision on land. So therefore it wasn't designated development. Just a couple of things to go. I'm going to hand over to some others, but just wanted to refer briefly to this little case in Inner West Council area. It was an application dealt with by Commissioner O'Neill, where we had this dwelling within a heritage conservation area. It was a building that was described as being in the Victorian Italianate style, erected in 1885, but heavily altered. You can see that nice brickwork on the front there, possibly not from the Italians of 1885, but what this case was about, though, was there was a character statement that went in the council's DCP that related to the heritage conservation area. It specifically identified this particular house as being detracting within the heritage conservation area. I wonder why. Commissioner O'Neill was convinced by one of the heritage experts in the case, Mr. Moore, that the description in the DCP, in the character statement of that building being detracting and not contributing to the heritage conservation area, was wrong. And Commissioner came to the conclusion that she was satisfied by all the evidence that the effect of the proposal to demolish that building would be detrimental to the heritage significance of the what was the Fife area, heritage conservation area pursuant to the LEP. That decision went on appeal again to the Chief Judge, and he didn't agree that the Commissioner was wrong in coming to a different conclusion to what the DCP said about the what was the heritage significance of that particular building. And ultimately, reading those two paragraphs, he said, yes, the Commissioner was required to look at what the heritage character statement was in the DCP, but she wasn't bound to have to agree with it. So she was able to, on the expert evidence, come to a different conclusion, despite it being identified in the DCP as being a detracting building, that it was in fact something that did have some significance and that its demolition would impact away on the heritage significance of the file HCA that meant that the application shouldn't be approved. It's in terms of that particular decision and heritage, we do a lot of heritage matters. Yes, the first thing you look to is the statement of heritage significance. You look to the DCP to identify contributory and non-contributory items if there are any that are listed. But ultimately, you need to come to a conclusion on your own, guided by expert evidence as to whether or not there is going to be an impact upon heritage significance as a result of the development that's proposed that relates to that particular item. Finally, I just want to talk to you about a case for the future rather than one that's actually been dealt with. Some of you are affected by the LMR provisions. RISE provisions, another acronym for planning law, but some of you might have tried, and I can see Dominic here. I've already dealt with Dominic Johnson from over at Marsden. We've had a look at this before, but when the government brought out these new provisions in Chapter 6 of the Housing SEP, it put out some indicative maps of the areas that were likely to benefit from the low and medium rise provisions in terms of the 400 and the 800 metre zone from the town centres. You go into that map and this disclaimer comes up. Thank you for visiting the low and mid-rise housing policy indicative map. While the maps provide an indication of lots that may be eligible to use the policy, please note that this is a guide only and should not be used to inform planning decisions. So you go to that map, right? So after reading that disclaimer and clicking that you're okay about that, this is a map that, this is the Marsden area, so you can see Spit Junction there in the middle, and there's also in another local government area you've got Cremorne and Neutral Bay further down as their town centres that are identified for the purposes of the low and medium rise. So the statutory line is a blue line that goes around the town centre. That is a statutory line. All of the tan shading is the indicative area of where you might be within 800 metres walking distance of that town centre, where the whoever is the little boffin in the department has tried to put tan over these areas with some tool. I don't know how that ended up over there, but there is an explanation as to why there's a gap there, because that's a different zone. So that's a C4 zone rather than an R2 or R3 or R4 zone. So that's legit. There is a legitimate gap. But you'll see, for example, in here, some of these lots really a little bit hard to see. Only part of them is coloured. Argument, right? So when we come to deal with this, you'll see that the provision or definition of low or mid-rise housing means land within 800 metres walking distance of land identified as the town centre, so that's on the statutory line on the map, or if it's within 800 of the public entrance or railway, metro, etc. They're all mapped as well, and it's for a light rail station listed in the schedule. So it's land within 800 metres. It's not lot, it's not allotment, it's land. So if only part of your lot is within 800 metres, can you do low and medium rise housing on that particular lot? I distinguish it from this provision, which is in an earlier part of the housing SEP. This relates to affordable housing, and you'll see the words there that say this division applies to development that includes residential development if all or part of the development is carried out. It says for development on other land within 800 metres walking distance of land within a relevant zone or an equivalent land use zone. That works if you've got a lot that is partly within the 800 metre zone and partly outside of it. But this provision, seems to me it doesn't, because it doesn't deal with those situations where part of a lot is within the area and part of it is out. In my, and that's, I'm not going to tell you what the answer is at the moment because we haven't run a case yet, but this is the one we want to run. So unless it gets amended. My understanding is the department are telling people as long as part of your land is within that 800 metres walking distance, well then you get the benefit of the provisions. I'm not so certain about that, but there will be a cure. There will be an amendment that happens if that actually goes to court and it's found that it only does apply to that part that is within 800 That's all I want to talk to you about today. There's a lot of things happening. Hope you got a little bit out of it today. I'm going to hand over to some people who are better than me to speak to you about a little bit of legislation for the next, what have we got, 30 minutes. So, thank you.
Thank you, Adam. As Adam indicated, continuing up until lunch and continuing with the legal theme, we now have two speakers who it seems have dedicated their professional life to local government and planning law, having practiced solely in that field since graduate lawyers. Peter Hudson, some 23 years, and Gisela, some 10 years. They're here to talk to you about changes in legislation.
Thank you. Good afternoon, everyone. So I'm Gisela, and I'm going to be starting by looking at some of the amendments made to the Environmental Planning and Assessment Act, which came into force on the 22nd of May of this year. They've been described as being the biggest changes in the last 40 years to the Act. I'm going to focus on three main areas because there were quite a number of changes, but I'm going to focus on amendments made relating to concept DAs, amendments relating to modification applications, and various amendments which impact community participation. So our first big change relates to concept development applications. Those of you from smaller councils may not have to deal with concept applications at all, or very rarely, because they are usually in relation to quite large projects and generally done in the cities. So by way of refresh, a concept development application is, as the name would suggest, an application which seeks to outline and lock in broader aspects, a concept or vision of a development, typically establishing a building envelope, but it can, but doesn't have to, establish other aspects of the development. For example, the number of stories, the number of car parking spaces. It really depends on the application you're dealing with as to how much is locked in by the concept. A detailed proposal is then put forward in subsequent development applications. So in recent years, there's been a number of cases handed down in the Land and Environment Court which consider the meaning of the words in section 4.24 of the EP&A Act, which I've highlighted in yellow on the screen, which said that any further development application could not be inconsistent with the concept approval. So developers needed to be cautious because once the concept application was approved, they would be locked into that concept design. To change the concept design would then require a modification application, or if the amendments were significant, potentially a fresh concept application to be made. Marsden has been fortunate enough to be involved in a number of the cases over recent years in the Land and Environment Court. The most notable, though, would be the decision of Justice Moore in the matter of Castle Hill Panorama Proprietary Limited and the Hill Shire Council, which in 2023 related to detailed development application that was lodged following a concept approval. So on the screen is a photo of the development that was ultimately approved. Originally, the concept was for 5 residential flat buildings, and the developer, through the concept consent, locked in the number of stories, parking, the maximum heights, percentages of open spaces, so quite a lot of the development was locked in by the concept. Then appealed in relation to the detailed development application, and this is what the case dealt with. Through the court appeal process, there were quite a number of changes to deal with the contentions and respond to issues raised, which resulted in there being differences to the heights of the buildings, the number of stories. They sought to introduce a neighbourhood shop, which previously hadn't been there. And as a result, there was an inconsistency between the concept approval and the development application. So as it happened, there was agreement between the parties in the proceedings, but the jurisdictional issue of section 4.24 of the Act, in terms of the words I showed you earlier about subsequent applications being inconsistent with the concept approval, arose, which the court needed to have regard to. In order to facilitate the detailed development being approved, it was necessary for the concept approval to firstly be amended. And in this case, Justice Moore agreed that the amendment could be facilitated through the imposition of conditions of consent on the detailed development consent, which required the modification of the earlier concept approval. So you'll see Justice Moore's quote on the screen, which confirms that the power to modify an earlier development consent by way of a condition does exist, and he describes the process. It was in light of this decision in particular, and I think it was even in this case was even mentioned in the first reading speech, that the New South Wales government sought to amend section 4.24, which it did through the introduction of a subsection 4, which is highlighted in red on the screen. So subsection 4 seeks to confirm that the approach taken by Justice Moore in the matter of Castle Hill Panorama is available to allow the modification of a concept approval as a condition of consent imposed on the approved detailed development application. Subsection 4 also goes a step further, and it provides an avenue of imposing a condition of consent for the surrender of the concept consent. Whether or not that would be appropriate, I suppose, would depend on the circumstances, whether or not that concept approval had any further work to do. For example, if the detailed development application only dealt with a portion of the concept approval and additional detailed development applications were envisaged to deal with the whole of the concept approval. So if it has work to do, it may not be appropriate for it to be surrendered. The next amendment I'm going to discuss relates to modification applications, and I imagine by now we're all familiar with the Court of Appeal decision in Biozo and Ku-ring-gai Council. The decision of the court fundamentally altered the long-held understanding of the modification powers in section 4.55 and section 4.56 of the EP&A Act. It was previously believed that they were available to modify any aspect of a consent, even mere conditions. But the court held that there are conditions or limitations on the exercise of power to modify a consent, for example, by looking at the substantially the same development requirement. So these conditions or limitations demonstrate that it is the development to which the consent as modified relates, which must be modified before the power is engaged. In other words, the modification powers are only available where some change is proposed with respect to the development for which the consent was granted. In the case of Biozo, the applicant sought to amend conditions of consent to reduce the amount of contributions that it was required to pay, because this was based on the calculation of gross floor area, which was found to be incorrect. But because this modification application didn't affect any change to the actual development, the modification power was not engaged. So in that case, they could not just amend the conditions of consent. It was in light of this specific decision that the decision of the Court of Appeal in Biozo that the New South Wales Government has now amended sections 4.55 and 4.56 of the Act to introduce new subsections highlighted in red on the screen, which expressly gives the consent authorities the power to approve modification applications which only seek to modify conditions of consent, even where there would be no change to the development, the subject of the consent. And you can see the same change reflected in 4.56. There's also been a number of other minor amendments which relate to this particular amendment. Changes to section 4.55 subsections 1A and 2 were also made that replace the requirement for the development to which the consent as modified relates be substantially the same. This has been changed to a requirement that it be the same or substantially the same, presumably to reinforce that no change to the development is necessary to approve a modification application. A further minor change that's been made is to section 4.55 subsection 1A. So this now allows modifications involving no or minimal environmental impact. So the words no and or have been added in there, which just acknowledges and addresses the court's position in Biozo that a modification or deletion of a condition may have no environmental impact. Finally, I'm going to discuss some amendments to the Act relating to community participation. The first change I'll be discussing relates to the notification requirements for State Significant Development, or SSD, which are found in Section 9 of Schedule 1 of the Act. Section 9 of Schedule 1 has been amended now so that the minimum public exhibition period for SSD is 28 days, or for a relevant SSD application, if there is a relevant community participation plan, which specifies a period of public exhibition for the application, then that period as specified in the plan. There's also a definition for relevant SSD application. It means an application for SSD that includes residential accommodation or housing development carried out by certain public authorities, infill affordable housing, build-to-rent housing or seniors housing. Now, with the introduction of the Housing Delivery Authority, we are seeing quite a number of developments being declared as state significant development. So this change in the notification requirements will become increasingly relevant, although not so much of an issue that councils need to deal with on a daily basis, because notification of SSD is primarily managed by the Department of Planning and Environment. Of more interest to council is the second amendment relating to community participation that I'm going to be discussing, which relates to submissions. And this change that's been made responds directly to a decision handed down in 2024 in the Court of Appeal. In the matter of Philotron, it was originally a Class 4 jurisdictional review appeal, which related to council's approval of a DA. The applicant, Philotron, argued, and the court agreed, that the approval of the development was affected by error. So in this case, Philotron had provided a submission outside of the original notification period, and that was done with the agreement of council. That becomes relevant then in the judgment. The objection raised a number of issues, and the assessing officer considered these in the assessing report and indicated that in their view they could be dealt with by conditions of consent and provided details of those. However, when the notice of determination was issued, they didn't carry through those conditions into the determination. So an appeal was lodged by Philotron, and the court agreed in the Class 4 matter. Justice Robson found that the assessing officer had failed to consider statutorily mandated matters of Section 4.15 of the Act, and therefore failed to properly determine the DA. Council had argued that because the submission was made outside of the submission period, the notification period, that the decision wasn't affected by error, because it didn't need to take into consideration that submission in any case. But the court found that even if a public exhibition period has finished, the council must still take into account any objections received as public interest matters. And then this went to the Court of Appeal, and the Court of Appeal agreed and found that Section 15 of Schedule 1 did not say that submissions may only be made during the minimum public exhibition period. So in response to the Court of Appeal's decision, the government has specifically amended Section 15 of Schedule 1 of the Act, which governs the mandatory community participation requirements. It's inserted subsections 3 and 4, which are highlighted in red on the screen. And it now makes clear that whilst a submission received outside of the notification period may be considered by the consent authority, it's not a submission for the purposes of the Act. And the first reading speech explains this change is really important because it provides clarity, particularly where the number of submissions determines who is the relevant consent authority. Okay, and I'm now going to hand over to Peter Hudson, who's going to talk to you about biodiversity.
Good afternoon, everyone. Peter Hudson. I'm a partner at Marsden's. David indicated I've been here for 23 years, so clearly I started when I was 10. And I've been here since I graduated from university. My son's now doing his HSC, so that 23 years really has flown by. I'm going to talk to you about the recent amendments to the Biodiversity Conservation Act, pursuant to the Biodiversity Offset Scheme amendments. These came into force, and most of them are now in force in March of 2025. In particular, I'm going to take you through three specific areas of amendments: the avoid, minimise and offset changes, the government's intention to transition the Biodiversity Offset Scheme to net positive, and cash contributions to the Biodiversity Conservation Fund. The government's intention when it brought in the Amending Act was given in the second reading speech to protect what is left, restore what has been degraded, and transition to a nature positive approach for biodiversity in New South Wales. It acknowledged that nature in New South Wales is declining and must be set on a path to recovery, that the avoid and minimise hierarchy be strengthened, and that changes be made to ensuring offsetting is genuinely used as a last resort. And it's been acknowledged that that's not happening at the moment. Now, my intention was to just simply take you through the amendments, but I appreciate that not everybody here is familiar with the Biodiversity Conservation Act. It's a complicated piece of legislation, and key terms such as what is a BDAR, what is the BOS, and what is the BAM are all important things that you need to consider. I'm going to be looking at the amendments from a planning perspective as well, so particular focus for the local council clients here in terms of what happens when you lodge a development application. How are these amendments changing your assessment of applications? So an application for development consent, in short, must be accompanied by a Biodiversity Development Assessment Report, or a BDAR for short, when a proposed development is likely to significantly affect threatened species. So when you receive a development application, if it relates to land where there's vegetation, and I'll get to the definition of that shortly, you need to carefully consider whether a BDAR is required. If a BDAR is required, the biodiversity offset scheme applies, and these changes will be significant. So what is likely to significantly affect threatened species? There are 3 tests. The first one is if a development is likely to significantly affect threatened species or ecological communities or their habitats, according to the test applied under the Act. Now, for some of you who are familiar with the previous iterations of the EP&A Act, this is the old 7-part test. So you look at the site, things such as, is there a viable population of species on the site that will be placed at risk of extinction? That type of impact is going to cause there to be a significant effect on threatened species, and a BDAR will be required. The second test is whether the development exceeds the biodiversity offset scheme threshold, which itself is determined under the biodiversity regulations. Basically, that's twofold, that test. Firstly, is there clearing of native vegetation above a certain area, and that area depends on the size of the lot. Or secondly, is there clearing of native vegetation from land that is on the biodiversity values map? So you should make yourself familiar with whether the biodiversity values map applies to the site, and you can view that map on the eSpatial tool. If you're able to get onto that, good luck with that. What is native vegetation, and what does it mean to clear native vegetation? Those definitions, curiously, are found in the Local Land Services Act. They're not in the EP&A Act, it's not in the Biodiversity Conservation Act. You need to go and look at the Local Land Services Act. So native vegetation means any of the following types of plants that are native to New South Wales: trees, understory plants, ground cover, so that can include grasses, or plants occurring in a wetland. Clearing of native vegetation includes cutting down, felling, uprooting, thinning, or otherwise removing native vegetation, or killing, destroying, poisoning, ringbarking, or burning native vegetation. So if, as a result of a development application, you are doing any of those things to anything that falls within the definition of native vegetation, you're going to need a BDAR. I was recently involved in a case that got all the way to day 1 of the hearing, where we attended the site. It was a large rural site, application for a single dwelling. A BDAR had not been lodged in support of the application because the dwelling was not touching any trees. But when we arrived at the site, it became apparent that the driveway that needed to connect from the road to the dwelling didn't remove any vegetation, but it was going under trees, and it was going to result in grasses being destroyed. It became apparent that that would involve the clearing of native vegetation above the threshold of clearing that's identified in the Act. So the applicant was faced with a situation where they have a DA on day 1 of the hearing, they don't have a BDAR, they promptly discontinued. So you really need to carefully consider when you receive a development application, is a BDAR needed? Because if it is, these amendments are relevant and Part 6 of the Act becomes very important. The third test for determining whether there is a BDAR is whether there is development carried out in an area of outstanding biodiversity value. There is a definition of that. I've never dealt with an application where there are areas of outstanding biodiversity value, but that's something that needs to be considered as well. If you do need a BDAR, it must be prepared in accordance with the Biodiversity Assessment Method. That's the BAM. I'm sure many of you have heard of the BAM. Put very simply, and if you ask AI to give you a definition of the BAM, it's a set of rules to assess the impact of development on biodiversity and enable the determination of required biodiversity offsets. So when you employ your ecologist to prepare the BDAR, they need to really carefully consider the BAM, because if it's not prepared in accordance with the BAM, that BDAR can be declared invalid and you've got a development application that's not properly made. So once we determine whether a BDAR is needed, the biodiversity offset scheme in Part 6 of the Act applies and these amendments become relevant. The avoid, minimise and offset hierarchy. So prior to the 7th of March 2025, when these amendments came into force, when a BDAR was required, the applicant was required as a threshold issue to demonstrate that appropriate and sufficient steps have been taken to avoid or minimise biodiversity impacts. So if avoidance of the impacts were not possible, a proponent could instead demonstrate compliance with the Act by minimising impacts. The amendments to the Act introduce a new avoid, minimise and offset hierarchy to development applications for which a BDAR is required. So firstly, the introduction within section 1.3 of the Act of the purpose. There is a new purpose to establish a framework reflecting the avoid, minimise and offset hierarchy. And that hierarchy is now defined in the Act. Previously it wasn't. So under the new hierarchy, a BDAR is required to demonstrate, firstly, that the proponent has taken all reasonable steps to avoid the impacts of the development on biodiversity values. Previously, if avoidance wasn't possible, and I'm sure every developer will tell you that avoidance is not possible, they need to put that building where they're proposing, they need to remove that tree, they need to remove that bush. If avoidance wasn't possible, there could be a minimisation of impacts. But now, the first step must be that a developer must demonstrate in the BDAR, and as part of their application, that they have taken all reasonable measures to avoid the impacts. After it's been demonstrated that those reasonable measures have been taken, the proponent is then to take all reasonable measures to minimise the impacts that have been avoided. Having taken the measures to minimise the impacts and avoid into consideration, the proponent can then take the biodiversity conservation measures under the biodiversity offset scheme to offset or compensate for any residual impact. And there is now a definition of residual impact on biodiversity values. Now, importantly, apart from introducing Section 6.3A into the Act, the government has not yet made the regulations which set out assessment standards, identifying what genuine measures to avoid and minimise constitute. So those regulations will be made. There'll be a suite of changes to the biodiversity conservation regulation or an alternative regulation, and we await with keen interest what those regulations will entail. Essentially what that means is this change, this introduction to the hierarchy really is the first step in the process of the government's intention to focus on the avoidance of impacts rather than simply allowing applications to either avoid or minimise. A developer cannot simply adopt a minimisation strategy first. Now, when I was looking at the new 6.3A, I was actually also at the same time preparing a statement of facts and contentions for a Hawkesbury matter. Hi, Craig. And I was looking at the Hawkesbury LEP clause 6.4, which is a common it's a common clause in the in the standard instrument, referred to as the terrestrial biodiversity clause. That clause is in most local government or most local environmental plans, and it applies to land that is mapped as ecologically significant, and it mandates itself an avoidance and minimisation strategy. So notwithstanding that you have a development application where a BDAR may not be required, if the land is still mapped as significant under the LEP, most councils already have the avoid and minimise strategy in place, and a development application will need to identify that as part of the application and as part of the ecological assessment, which won't be the BDAR, submitted in support of that application. If a BDAR is required, it will have to also comply with this. The court has not yet dealt with or made any comment on the new avoid minimise hierarchy. There's been an acknowledgement of the new section 6.3a in some recent decisions, but other than acknowledging that it exists and agreeing that particular applications that have come before the court have identified that there has been sufficient measures to avoid impacts on native vegetation, there's been no commentary on what would constitute avoidance and what will constitute a genuine attempt to avoid. Okay, transition to net positive. So the government, in introducing the amendments, has identified that it has an ambition to transition the current biodiversity offset scheme to net positive, to improve biodiversity in New South Wales and not allow it to simply be maintained or declined. What's the biodiversity offset scheme, you might ask? So put very simply, it's a scheme, it's a system where developers can compensate for the negative impact of development on biodiversity by funding conservation actions elsewhere. So it aims to ensure that development does not lead to a net loss of biodiversity, and now the government has started the process of ensuring that it will not only be net loss, it needs to be net positive. There is a new section 6.2a that's been inserted into the Act, but quite frankly, that's all that's happened so far. There's a new section which talks about what the minister can do and what it should do, but nothing's happened yet. So 6.2a essentially requires the minister to make a strategy for the transition of the biodiversity offset scheme to deliver net positive biodiversity outcomes. Public consultation of that transition will be mandatory, and the minister must make the strategy as soon as practicable after the commencement of the section. So the section commenced on the 7th of March. I've just put an extract of it on the screen. Commenced on the 7th of March. We're now the 20th of June. I'm not sure what the government sees as soon as practicable, but from what I can tell, there's been no commencement of any action to identify what this transfer or what this transition to net positive will entail. I appreciate it's going to be complicated, and I wait to see what the government does. Section 6.73 of the Act has also now been amended or introduced. There. And it requires the minister, when establishing the biodiversity assessment method, so that's the BAM, which I spoke about earlier, it's how you prepare a BDAR. So when establishing that method, which undergoes changes quite often, the minister must have regard to the strategy for the transition to deliver net positive biodiversity outcomes under 6.2A3. And in doing that transition, adopt a standard that will result in no net loss biodiversity to New South Wales. So overall, the government is just bringing in at this stage this concept of a transition to net positive, and that will permeate into how BDAs are prepared and what must be considered when they are prepared. So with these amendments, as I said, there's no immediate change in practice, but they will pave the way for future change. So lastly, the amendments to the Act also change the way the Biodiversity Conservation Fund works. And I'll put quite simply, at present a developer who is required by a development consent to retire biodiversity credits may satisfy that requirement instead of retiring credits and physically finding elsewhere for the vegetation or the vegetation that's lost to be planted. They may instead pay an amount into the Biodiversity Conservation Fund. The government recognised that the Biodiversity Conservation Fund currently operates as a default pathway for many proponents, but it sees that should be a last resort, not a first resort. So we don't get to the point where you have to retire credits. We'll just pay some money, cause the damage on the site, and we're done. The government's preference is for genuine attempts to actually address that biodiversity impact rather than paying into the fund. The cash payment is determined in accordance with the offset payments calculator, and this is presently the way the legislation works. This has been a feature of the biodiversity offset scheme due to the difficulty of acquiring credits in the open market to retire, where you've got a very particular species that you're trying to offset damage to. It can be very difficult to find like for like to offset that damage. So there's an opportunity to pay money into the fund to offset that. So in short, landowners have not embraced opportunities to create those credits, and there's simply no credits available to purchase. Hence, a payment is made into the fund. So the amendments to the legislation will now allow the government to make regulations which limit the ability for a developer to pay cash into the Biodiversity Conservation Fund in lieu of retiring credits. Those amendments haven't been made yet. So the amendments to the Act simply allow the government to make legislation which limit the ability. We are yet to see what will entail from that. So a takeaway from these amendments, we can see what the government's trying to do, but it really is a work in progress. Real changes to the scheme are yet to be seen, but they're certainly foreshadowed, and the aim is to achieve a net positive status for New South Wales. So it's a watch this space. Thank you.
Pete's asked if there are any questions. I don't know, any quick questions before we break? Thought so. We will now break for lunch. Before we do go, we really do encourage all of you to come back at 2 p.m. for our forum panel this afternoon. We're really quite excited by it. We have a new facilitator who we're told will have a new, fresh approach. We have a bigger panel, and we also have participants in that panel who are of the highest reputation and calibre, really, not only in local government and state government, but also in the private development industry. So please now go and enjoy your lunch, and we look forward to seeing all of you at 2 p.m.
Thank you. I had to consolidate it.
Okay, so it'll be 28 days, but then if there's that relates to a relevant application, it'll yeah, thanks for letting us know.
I have no idea what the time was.
Half an hour. We will.
You start having going off script. Yeah.
It's good if you put, yeah, I like the order.
There's a gig
I might leave.
Check. Hey, 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 hey. Ju- Yep. Awesome. That's what I thought it was. So it's just on, and I'll be needed upstairs right now, but I'll just move as we go. So we'll just put it in the back. Just finish. And where would you like the pack to sit? Just anywhere?
My belt?
Yep. That's all good. We're ready to go.
Great.
All good.
Thank you. So where do you want us?
So you'll be on that seat.
I'm over there, yeah? Okay.
Facilitator, and then everyone else.
Was at the office. Yeah.
So you, how long have you been back at Randwick? You were at Northern
I
Beaches.
was at Randwick for 15 years.
Yeah.
And went to 5 years to Northern Beaches, then back here for 2.
It's 2 o'clock.
Yes.
You want to do a sound check?
Two speakers, so
Sorry?
we're still missing 2 speakers.
Oh.
I think
Ray.
Tom and
Oh,
Stuart.
Tom and... Oh, that was odd, because he was behind me on the motorway.
Oh, well,
Yeah.
which Tom or
Forrest.
Forrest.
No, he was behind me on the motorway.
Oh, Michael, that's it there. Put Gal there, mate. You don't want to put us two in the middle. Us two old blokes there.
Well, okay, I'll go at the end, no?
Let's go there.
Two wild blokes in the middle.
Gal, you're there.
Forrest is sitting on the freeway behind him, so...
You're there.
Yeah.
I'm in the middle, am I?
Yeah.
So I can attack both sides equally.
Basically, yeah.
Don't be scared, Ray. It'll be okay.
He's been here for a while, so he must be here.
Why? Yes. What's the time? I got here about 1:30.
All good.
And it's...
So if it's okay, I'll just
You
put
can
it down the
tell
back
me
of
you can't.
the
There's something behind
jacket,
you.
just so it's... yeah. Yep, put the jacket back on. Excellent.
These guys don't come up with
Don't worry about being too careful. I won't.
That's right.
I don't mind being inappropriately touched. It's okay. It's okay.
Yeah, some people just really don't like.
What do you need?
Yeah, we're missing 2 more, so we're going to go.
And we'll just
Have you got a number?
talk to you on the And he said, make sure you say
Quickly round it up.
Just...
Oops, sorry.
I actually find it pretty good value.
Frank was...
I don't know how you got that.
And what I liked about him as a minister
Thank you.
Brilliant.
Thank you.
Very well.
Hi, Gail Connolly. Hi.
When Bob was on the way out, he said, look, the makeup of your ministry is your business.
I'll go to the first seat. Why not?
Give Sartor planning. So I gave Sartor.
Oh, here's Tom.
I think he's furthest to the right of the panel and shared an opinion.
and we really often a bit.
I remember you
Yeah,
from the parties at
I
John's
mean,
house.
he lost his
used
cool
to set up
sometimes
and
at
have
meetings.
all the different council lunches. Remember them at Christmas time?
You could hear the screaming.
In the good old days.
I
You could hear
know,
the
the good old
screaming
days.
from down the
and John used to
corridor.
scream at us, get that beard out.
But he did.
Everyone used to disgrace themselves.
Yeah.
Look, he also was pragmatic
It's
too.
more fun to work at.
Can you imagine the possible workers' comp claims and the bullying and harassment and everything? Imagine if John was still alive and the things he used to do.
I know, I don't think it wouldn't work.
Oh, thank you. Where's Scott? I was going to say, I still remember the very first time Scott Phillips met him. I employed him as my development manager and I was a director. And John came in and insisted on having a meeting with him, and John had already said to me, "Oh, he's very, very attractive, very handsome. Leave him alone." You know, I said he's married. Anyway, I remember saying to Scott, "He's going to come in. He's going to say something really inappropriate, try and shock you." And I said, "And it'll be a test." And I said, "You've got to remain calm, don't react, and even better if you've got some sort of, like smart ass comeback." So, anyway. So he did. He came in and he talked about how he was partying all weekend, had taken all this ammo and had sex with all these people, and then looked at Scott and said, "You're very attractive. You're married, you know." And then tried to take it further, and yeah. These days you'd have a claim.
Oh, I know.
Straight away.
I know. Even in the office, like the way he used to be with all of us staff, I think there's no way now. But back then he kept it all going in a team, and it was amazing.
The days when you could comment on people's appearances and
We weren't allowed to wear pants in the office.
I remember.
Okay, John said, okay.
Yeah, things have changed a lot since then.
When was the last time we did one of these for him?
For Adam.
Yeah.
Oh.
My
It was at George's River.
My last one was the mergers, before the mergers happened. And I had councillors from around who were anti-merger sitting in the front row and telling about how great it is. They said, what did you want for the sort of political support? All the smart ones know it's the right thing to do. Just
outside.
It's a big panel. Well, it was 9-0 in the penalties at this stage, so
I'd say if we kick
remarkably Queensland became defenders.
Yeah.
mathematically correct. Yeah. If we kick the goals that we had the opportunity to get across,
Five, 1 from 5.
One in the post.
We'll just sound check and just double checking.
Yeah, that was the first. Just
What was that?
yeah, that would have changed.
Is that what we had to modernise, modernise the modern obstruction rules pretty clear. There's no doubt. Even immediately, we ran through we blocked the pathway. You should have either run straight through or got out of there. As soon as you saw the South Wales still had a chance, you should have got out.
Man, I've cut number 3. Oh,
So we've got a list of all the people that were here at before lunch. There's less people, and they're all cleaning staff. Between the three of us, we've been fucking all over. I'll tell them.
We can, indeed. Well, it'll be interesting to see whether my governance guide turns up because I'm just going to hide this bag around here because I'm about to sack him. Yeah.
And George is going well? No, he loves this sort of stuff. Just keep doing it.
He loves the behind.
Mate, I wear ties at weddings and funerals these days. Weddings, funerals and race days.
Or if it's really, really cold.
So,
That is.
I think 5, 6,
Because blah, 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 blah. Okay, you're enough. Oh.
I have some notes while you're all professional planning and people.
Oh, I'm not a planner.
just make it up as you go along, Judy.
Yeah, well, that's usually what happens, isn't it?
Is there a seating?
Yeah, you're outside. You're outside, Tom.
You'll hear me.
I know. It's like-
Right. Jim Marsden owes me a lot for coming constantly to.
Yeah, how are you?
I'm never going to get it back from Jim.
Yep.
There we go. That works.
Yes.
Certainly comes through,
Yes.
I think.
Yes.
Yep.
So the program. Yeah. Yeah.
Yeah.
And so I sent to Adam about
Just taking off my
discussion points and topics.
tag.
Is there anything published on the program?
I know who I am.
So I'm going to start with you first.
Okay.
What's your favourite meal?
All right. Yeah. Okay. I'll do that.
I'm on the other side of the Red Rooster line, so I'm going to go Red Rooster chicken roll.
I'm just going to get a coffee.
Favourite meal?
Yeah, today.
Good. Oh, today?
Today, just today.
The slider outside.
Hey, Sisai, how are you? Going well?
Do we have to talk about food?
No, you can have them just...
There's this horse that walks into a bar.
Yeah.
Oh, I'll stop there.
Okay.
I'm loud.
Not that loud, Dale.
Just because...
Let's bring it over the other side. Go around the back.
Yeah. Oh, no, not really. I think.
Good, how are you?
Yeah.
So am I.
No, I think it's. Yeah. No, I'm fine. Yeah.
Is that better?
Yeah.
Better or worse?
I can hear
Check.
you.
Check. 1, 2, 3.
4.
You need a mic.
Yeah,
There you
there
go.
you go.
Can you hear it? Yeah.
I can
There we
hear
go.
it.
So the coffee and the sliders.
Coffee and sliders.
Yep.
Oh, okay.
Can't
Keep
hear me?
going.
So the coffee, the sliders, the water's not too bad. I also like Gail's horse that went in the bar.
And you're perfect because it's really close to you.
I'll bring the slider.
Have you tried one?
That's a lot better. Yeah, no, that's
No.
good into it.
Mm. I can't tell any other jokes because they're all inappropriate.
What's your favourite meal for today?
Sorry?
No, it's clear.
Testing?
Yeah.
1098.
We got a good health system despite the bag.
So when we decided to move all of our red guys down there, because they had all the rangers and partners up in Church Street, we wanted to move half of them down there so they could start in the northern part of the city and half start in the southern part, you know, their shifts. We had this problem with car parking in the house. So that's sucking into it, put that on there, and it's not going back to an LPP panel to, you know, and then there was all this thing around what we called it originally and whether we could do whether we could do a bit of a change of use and do a CDC on it. So that's why we were having these conversations. We should be giving ourselves a good accuracy of our true conditions. Let us do anything, any time of the day or night, not limited in hours. We don't talk about
Afternoon, everyone.
So, yeah, make sure you get a friendly planning consultant.
We have.
Welcome back. We'll now commence the forum panel, something that we look forward to each and every year. This year, however, something new. We have a brand new facilitator, a man who probably needs little introduction to most of you here, having regard to his history, but it'd be remiss of me not to remind us that Maurice Yemmer, our facilitator today, was a Premier of this state, in fact the 40th Premier of New South Wales. And during his time as an elected Member of Parliament, also held positions of Treasurer, Minister for Health, Minister for Public Works, Sport, State Development and Community Relations. Since leaving Parliament, however, Maurice has continued a relevant involvement in public affairs. He served as Planning Commissioner for the South District with the Greater Sydney Commission, Board Director of TAFE, Chair New South Wales Government Cancer Institute, Chair South East Local Health District and Chair of Greyhounds New South Wales. As co-founder and CEO of IPPA, Maurice now leads a bipartisan government relations advisory firm renowned for its deep understanding of governmental operations. Maurice has gathered here for us today an illustrious group of participants. I'll let Maurice provide a brief introduction with respect to each participant. You'll see the topic. We don't know where this will go, but Maurice. Thank you.
Thank you. Thank you. Well, it's an excellent panel. We've gathered here experience from local government. So we've probably got three of the most senior practitioners and professionals in local government who represent three LGAs that are going through all of the policy issues, the implementation issues, the delivery issues of the national agenda on housing, the delivery of infrastructure and amenity, from Michael Edgar from the Hills. The Hills is an area that's a focus of infrastructure with metros, obviously the Housing Delivery Authority, lots of applications, and lifetime professional in local government. And next to him, someone who's a wealth of experience in planning, local government, New South Wales, Queensland, a local from Southwest, the family, Gail Connolly, her family's from southwestern Sydney.
Seatown. From Seatown.
Indeed, and lots of family in Wollondilly, in Camden, LGA, and head now of Parramatta, having served at Ryde, at Georges River, the amalgamated Georges River. Gail was, I think, the first CEO of the new council, bringing Cogra and Hurstville together, and now at Parramatta, one of the crucial local government areas of New South Wales with the Parramatta CBD and just about every piece of infrastructure from, like, you've got light rail, metro rail, the traditional heavy rail, massive infrastructure development in health. Westmead Children's Hospital is not far from completion, and lots of things happening in and around the Health Innovation Campus anchored by Westmead and the other public hospitals. Ray Brownlee now at Randwick for a second term. And
loving it, Maurice.
And loving it, the People's Republic of Randwick. And Ray having done a stint prior to that at Northern Beaches, and prior to that was 16 years at Randwick. So we've got
I dare say, almost a century of experience in local government and in planning.
You're that old.
Next to Ray, Judy Ham, who's also had quite a long experience with local government and now representing Wollondilly in the New South Wales Parliament, independent as a member of the New South Wales Parliament. And next to Judy, Tom Forrest, head of the Urban Task Force, one of the two industry bodies represented here. No, and I haven't forgotten Stuart. I'll come back to Stuart in a second. But Tom is the Chief Executive of the Urban Task Force, one of the key industry bodies that governments consult with. Extensive membership of participants in the planning and development space, one that's never shy on giving governments, media and individual politicians the benefit of his opinions on the planning system, success or otherwise of housing targets and housing delivery. And to my immediate left is Stuart Ayres. So Stuart is a very long-standing member of the New South Wales Parliament in the last government, a very senior member, a plethora of portfolios, and in his post-political life, since leaving politics, heads up the other major industry body, the UDIA, and along with Tom, probably not to diminish the Property Council in any way, not at all. The Property Council's the third of the industry bodies, but probably the two that have had, I think it's fair to say, a public media profile, more of a media and public profile, particularly on housing targets and reforms in this area, being the UDIA and through Stuart's work in interacting with government and also the media and the various policy bodies that the UDIA has in interacting with government and government changes or reviews of policy. So two of the three major industry bodies. So don't think you'd get a better panel to take on this afternoon's discussion. The program, the official program says there is no certainty in the planning and development system of New South Wales. Well, that's a startling revelation. How can this be fixed? I'm not going to ask you that question, we'll come to that later, but I thought maybe we might kick off because we are in the final week, which will bring to a conclusion the first year of the Housing Accord. And I thought, given that we've got three chief executives from three of the most important local government areas in New South Wales, the nation's largest jurisdiction, an elected member of Parliament, and the two industry bodies, I thought just to throw in and kick off the discussion. We're about to come to the end of year one of the Accord. Your thoughts, reflections, good, bad, a success, a failure, more to do, heading in the right direction, or a fundamental rethink is needed? Correct, yes. Stuart.
So I like to think of it as we got a really good preamble. So we had a nice period of time to warm up. So we knew that when we got to the end of the first year, we'd have a pretty good sense of how we're tracking, which is fair to say badly. We're nowhere near it. I think UDIA's research shows that we're likely to fall 150,000 homes short by the end of the 5-year Accord period right now. I think the government relies heavily on LMR and TODs to be able to deliver the numbers that allow them to talk confidently about achieving that target or being on the right trajectory. I think a lot of people in this room would recognise that TODs are probably going to fall outside of the 5-year period, and LMR's only just starting to get going, so probably some doubts around that. My biggest concern right now is whether we need to actually do a bit of a recalibration around what happens in the 5-year period after 2029. I think where the lead-in times, I think there's a real risk that if you start to recognise you're going to miss that number by such a long way, the measurement performance metric and the way it shapes and influences decisions, I think will also start to diminish. And so whilst we may only be 1 year in, I think there's a serious argument for why we should be thinking about a housing accord over 2 phases, perhaps 2 5-year blocks. to focus on the things that can be delivered in the near term, and then also set up so that there's no pressure coming out of the policy making system in that 5-year period after 2029.
So with our 3 local government representatives, given what Stuart has said, your reflections and thoughts on, one, the first year, the Accord, and some of the issues that Stuart has raised. So clearly a focus on TODs, there are targets. I mean, we're in the lead up to the commencement of this session, we were discussing with Michael how HDA applications have been going. There's a heavy concentration in the hills, so and there are some in Gales area, less so yet in Ray's area, but there are a whole range of other issues in Randwick. But just very quickly, and then perhaps pick up on some of the things that Stuart said.
Look, and thanks for the opportunity to be here. And I've just noticed a couple of Star Hill Shire staff in the room. They've just got their KPIs for the year for coming back after lunch to listen to me. The year
Double professional development points. Yeah.
The year has been another one of probably a decade or more now of pretty significant housing growth in the Hills Shire. And there's a couple of fundamental reasons why that is still cooking. And I think if you look at the so-called league table, and we all look at that with some trepidation, you see that we're either 1 or 2 next to Sydney City in terms of number of dwellings and capital investment value. So there's still plenty of investment and plenty of housing underway and being built in the hills. It's fair to say there's a lot more that is approved that could be built. So it's telling you that feasibility is still a problem even in the hills, despite it going at unbelievable rates. And to put those rates in perspective, I'll give you 2 sort of stats. When I first came to the hills 20 years ago, we probably averaged around 450, 500 dwelling lots per annum. And for the last 10 years, it's been over 2,000 per annum. And I think at our peak, we hit 2,700. That's a lot of housing. If you times it by roughly 3.2, that's how fast the population's arriving. Probably by about 2.5, and that's how many cars we're getting as well. So you can see why when you get into the northwestern, along with Blacktown, why things are hard to move, why services are hard to access, and why we're experiencing some growing pains around this sort of growth. But there's reasons for that. I think there's been some really good plans that have been built upon over the last 20 years that has directed investment, because it's not easy in the hills. The land's dear and it's fragmented. So we're not dealing with one developer. We're dealing with lots of developers, lots of mums and dads and those sort of things. So you would think it would be a slow burn, but there's some key infrastructure that's come along. And I think if the government could learn anything out of the hills in terms of trying to meet housing targets, because I think feasibility is your biggest block at the moment, is you've got to fund the big infrastructure that makes people want to invest. And I'm talking about the sewer, the water, the power, but roads, schools, and your motorway networks and whatnot. If all the shots in the arm that came in the hills and the momentum that's in the hills is really on the back of some pretty significant investment by government in some of those sorts of infrastructure we're talking about. So M7, M2s in the early days. Later on, it was the metro. And the metro has fundamentally changed the way we think about movement in the Shire, but also movement out of the Shire. It's a terrific bit of kit, and it's no surprise why government's looking for those metro stations to do a lot of heavy lifting around apartments. However, they are a longer pipeline than some of your traditional greenfield.
Yeah, and you've hit the nail on the head, Michael. The Housing Accord was about supplying houses, not about fixing the planning system or fixing the supply of infrastructure or any of those things. So just to announce a Housing Accord with some targets, some housing targets in it without fixing everything else behind it, you're always going to struggle. Always, you know, the investment in infrastructure that needs to be aligned with housing supply, fixing the feasibility issue, the amount of contributions and the costs of finance these days and the risks behind that, all of those things sit in the background. So, you know, the problem with announcing a housing accord and saying we're going to build these number of houses is that you're only, you know, the government's only in charge of a little bit of that. And what it can control is the infrastructure, the amount of contributions it levies, things like that. But at the end of the day, you've got to have developers who are willing to build, get the finance, get the feasibility right, take the risk. You know, Parramatta and Hills are lucky we have massive growth. We hit our housing targets. Not a lot of other councils can in terms of approving dwellings and new homes. But it's, as Michael says, it's one thing to approve dwellings and apartments or single dwellings. It's another thing to get someone to come along and build it. So, and that's the missing piece in the housing accord. Even if the councils did all of the heavy lifting and approved every single thing that came through our door, they're not getting built for all of those other reasons, because the accord's only addressing the supply and not the underlying problem of how you get that supply to come to market.
Right.
And I agree with what Stuart said about the first 5 years of the housing accord is not long enough. It should be longer than that. It's year one of the housing accord, and this is a problem that needs to be fixed over a long journey. Just dividing the 5 years by just dividing the number by the 5 years and saying, well, we're below the target, that doesn't help anybody. There's things that we need to fix, such as the construction workers, the training. We need to fix the cost of materials, and that'll all take time. Yeah, we've just come out of the pandemic. The government stimulates the economy, which is the right thing to do. We have low interest rates. We have a construction boom. And next thing we're doing, we're now pumping more approvals through the planning system to meet an accord. It takes time to do that. Just thinking that we can each year meet this linear target of what numbers we should be in across the country is not realistic. And I totally agree with Stuart. We'll get there. We just need time to get there. Michael touched on one of the issues with the lead tables. I can tell you as a general manager and the general managers in this room, there's nothing more motivational than us to be put in the Daily Telegraph with how your councils compared to other councils. So that's a good thing the government's done in doing that. It certainly motivates us to do that, and I'm sure the GMs and CEOs would be telling that to their particular staff. I do note, by the way, that that's fine for us, and we get measured on per days and things like that, but the state agencies get measured on percentages, which I don't think is quite as transparent as we
fair.
can say.
Fair. Just say it.
That happens for us. So I think that could be a change there, but certainly there's the labour cost and the feasibility, as Michael was saying, are big issues for that. It's not. The councils are doing, as Gail said, what the Premier's asked us to do, the heavy lifting as far as approvals and getting our systems quicker and that to get the approvals through and that. But certainly there's some structural issues that need to be done through the economy that will help finally get to where the targets that we need to get to.
Bring on the state agency league table from DA to CC and see which state agencies clear out all the consents the fastest.
Well,
Publish, shine a big light on that.
Transport.
Water New South Wales.
So would you like me to... So I have notes here. I feel like a bit of the odd one out here, not being educated in local government, just taking experience on board. The first thing I wrote is all well and good to have numbers without the backing of the infrastructure. Just as everybody here said, we're not going to get anywhere. Who in this day and age would expect to be delivering new greenfield sites, houses people living in, that are having their sewer trucked in and out every day? And that's actually happening on the ground. So while we talk about numbers, what are we going to deliver? Are we going to deliver these communities out there with none of the infrastructure, none of the transport, none of the connectivity, none of the health, none of the education? How are we going to leave those communities there? We might attain the numbers, but in a couple of years we'll be having a different accord about those communities that are sitting out there not being able to afford where they're living. So that's my take on the housing accord.
Tom.
So I think my role will have to be just to offend everybody equally politely.
So we were waiting, Tom, for you to do that. We did the same to you.
So I'll start off with the idea of targets. I think are absolutely essential, and even if you're not getting to the targets, you've got to keep reminding people of what they are, so you can judge exactly how far you are behind, and that can moderate behaviour going forward. So you've got some chance of catching up with that target before the end of the 5 years, and in an ideal world, you'll actually be ahead of the target, making up for the years where you had a shortfall. Without the target, you've got nothing to inspire. I mean, we had Western Sydney Airport committed to being built. We had the metro out there from St Mary's to Bradfield. Goodness knows why they stopped it and didn't go all the way to Leppington, but whatever. All committed, being built. And yet you couldn't get, for love or money, any funding for the upgrade of Elizabeth Drive or 15th Avenue or any of the service roads which were going to make that a real community with real jobs and opportunities for both employment and new housing supply. You need the target so you can hold the politicians at federal, state and local level accountable for how they're going. Then you can publish the league tables to see how each of them are going compared to their colleagues. The state agencies, of course, they should always also be held to account for how they're performing, the time taken for approvals, how many approvals are facilitating, how many houses in each different area. And one of the things I do every single month and also every quarterly with the completions data on approvals, I publish a league table on each of the states, how we're going against Brisbane and Victoria, how we're going against Queensland, how we're going against WA. That motivates the state politicians. So there is an opportunity for having a target, then publishing performance against the target, and then encouraging and supporting. And that, of course, then needs all of the things that it's already been talked about. It needs money going into infrastructure. It needs alternative thinking about how we deliver that infrastructure. How can we use the private sector to pay for that infrastructure through works in kind? Got a bit of media in the last couple of days. There's lots of different questions, but the targets show us what we need to house the population that we know is coming, and if we ignore that, we just send people into poverty and homelessness.
We didn't manage to offend anyone just yet.
I might.
So
it's great. But it's about mass planning. It's not about one developer coming on board and just doing a development here that doesn't join up with the other ones that are attached to it. With the proper planning, instead of being siloing in government, a proper plan that everybody can contribute to.
Correct. So Tom, you mentioned the airport. You were around in government when the Olympics were on. And the Olympics, Queensland's about to go through it with their planning. So for the Olympics, there was a thing called the Olympic Coordination Authority, which was established, and its job, we had a drop-dead date, the second or third Friday in September 2000. Everything had to be done, built, finished, open, tested, and the world was watching. We're told this is a housing crisis. We've got a national government, state government, local government, all three levels of government involved in the effort. We've got targets, we've got an accord, it's 5 years. Is there a case for a National Housing Coordination Authority to deliver the targets, to ensure the infrastructure's there, the coordination, wave the big stick, dangle the carrot? Is this not the Olympics wasn't a crisis, but there was a drop-dead date. This is a crisis and a first iteration of a contract, 5 years, so that these issues are dealt with in much the same way that the Olympics were.
So let's have a chat about the constitutional roles of both the Commonwealth and... No, let's not. Perhaps we could have a chat about vertical fiscal imbalance and the fact that the Commonwealth are the ones with all the money.
Is there a case for now that the Albanese government's re-elected, got a massive mandate, they've said they want to do more in this space. What initiatives, additional things can they do?
It's quite right, Morris. There's no one from the Commonwealth here, so they're going to cop it with both barrels. The fact of the matter is they're the ones that set up the Housing Accord targets, 1.2 million. They started at 1 million, then they actually upped it to 1.2 million because they realised 1 million wasn't going to be enough to house the growing population in the post-COVID period. Secondly, they brought in the immigrants. I mean, we all know, and we supported that as a business community very, very strongly. Everyone knows you couldn't run a business. There were skill shortages in every single industry in every single place. So we need the population growth. They were right to bring in the population growth, but they were negligent in not taking a very proactive role in supporting the states in the context of virtual bankruptcy of the states in the post-COVID period. They don't have money for infrastructure rolling out of their pockets. All of the states, every one of them is struggling with their budget bottom lines, while while Jim Chalmers delivered 2 budget surpluses. How did he deliver those 2 budget surpluses? With very low levels of unemployment, driven by the shortages in labour supply, with very low levels of unemployment, and by heaps of immigrants coming in who went straight into jobs, generating taxation revenue for Jim Chalmers. Couldn't he have spent some of that money on supplying the infrastructure that would have helped the communities that need to be growing to deliver the houses to support the very growth that he says he really wants as the Treasurer of Australia? So I think their role, Morris, is not in coordinating the delivery, because I've seen the way that the Commonwealth manages the delivery of everything from submarines to pink bats during a GFC. I don't trust the Commonwealth to actually be delivering anything, but should they be monitoring and rewarding those states with financial incentives, some carrots to say, here's some money to support your local communities, here's some money to support the open green space or the public playing fields, to improve the greenery of your areas, to support the amenity of your areas. Here's some money to build the extra schools or the extra hospitals or the extra roads that are required or the extra public transport links that are necessary, to build that water infrastructure, which means we don't have to truck the sewage out of new communities. Absolutely, they should be doing that.
Is there, and for our local government representative, perhaps Stuart as well, given what Judy has said, is it one for the states then, given lots of applications approved, HTA, you've got this massive growth, Gail, you're in a city that has heavy rail but has had the metro investment, light rail investment, there's ferry investment, so a state coordination that addresses your concerns about keeping pace with the growth in your area, delivers what Judy's looking for, a greenfield estate being open and the sewer's not connected, or insufficient electricity infrastructure. There seems to be, everyone's in agreement there's a crisis.
Are we? Really?
Well,
like I hear this all the time, right?
Yeah.
But the question and perhaps...
Well, perhaps we'll come to that, because that's a fair question. Is there a crisis? Some people are posing that, but seems to be a consensus that there is a crisis. But what are the additional measures that can be taken that addresses some of your concerns? Leaving aside feasibility and whether there's too many eggs in the density basket, we'll come to, because they're topics for later. But just in terms of year one, the end of the Accord, a re-elected government, a massive mandate, and they've said we want to do more in this space. If it's not the national government, then it's the state government to address the issues that 3 of the biggest and most important local
I disagree that it's not the national government. If you think back to Snowy Hydro, the nation had an energy problem. We built Snowy Hydro after the war, 16 power stations, etc., because the Commonwealth government recognised that there was a problem that was nationwide. Tom has just said there's a nationwide problem with housing. If you're going to announce a housing accord, I think then you've got to back it with a version of the Olympic Coordination Authority. The reason why the Olympic Coordination Authority worked, because it turned off all the usual planning rules and regulations that got out of the way, streamlined systems, and you got things built and delivered on time. That's the power that the feds would bring to this equation. Now, you know, if I was running the federal government and housing supply, I'd be establishing an agency in every state that had federal powers, that had intervention powers. You wouldn't be waiting 5 years for water and sewer infrastructure. Houses come and then 5 years later you get a sewage treatment plant. It'd be the other way around. And that's the power that the feds can bring to this equation. So I partly agree with Tom, they can bring money, and I partly agree that there should be a state-based solution, which is traditionally state legislation. But the feds bring a lot of efficiencies. They can bring efficiencies in the planning system and override rules that we currently have, and they can also bring dollars. So my view is that there should be a housing accord office, or call it whatever you like, in every state. And they are the ones who, just like Snowy Hydro, come in and plan the infrastructure, deliver the infrastructure, and then the councils can come in and the state governments can come in behind and back it and fill it in with approvals.
Right, Mike?
I think all levels of government have to have a role, and I think what we've seen, I have to think back to the early 2000s before I've seen a federal settlement policy. I think it was a minister by the name of Kim Carr who had the last stab at basically a population policy and a settlement policy. And I think that's severely lacking. So if for other economic reasons there needed to be a massive uptick in population, whether that's homegrown or whether that's immigrants, it doesn't really matter. There's been a decision made that we need that level of population growth. There needed to be a settlement plan and a housing plan around that. You just couldn't leave it to work itself out. I think if I come back to a point I made earlier more locally though, there are many, many, many houses already approved but not built, and if I even set aside the feasibility problem, because that will change. It has in the past, that will change. And I think we're on the cusp of that changing with the movement in interest rates and other things, and labour costs and materials costs coming back a little bit. We're seeing it in our own tenders. But if anything I could say, it seems to be very partisan now as to where schools and roads and some of these big infrastructure announcements are being made without necessarily a link to, well, where's the action actually happening, or where do we need it to happen or continue to happen while the feasibility improves? Because there are parts that are, the approvals are there, but it's just completely unacceptable when you get a letter from Sydney Water saying, look, there's no Section 73 certificates for the next 12 or 18 months until we work out what we're going to do with sewer and water. That is completely unacceptable. It's unacceptable to the councils who are in a league table being blamed for not hitting targets, and it's completely unacceptable for the development industry that's expected to invest and actually make this happen. I think the coordination needs to be around the infrastructure around where the growth is expected to happen.
So, Morris, whether you need a state coordination authority or not, I don't think anyone in this room could say that the Premier of the state, the Planning Minister, and certainly Kirsten Fishburn are doing everything possible, putting all the levers in place to put as much supply back into the planning system for all of us. They're doing that. They've got the Housing Development Authority. They're finding ways to fast track that to get projects moving, to do that. So I think that's already happening at that level without actually calling it a state coordination authority. Just touching on Tom's point, and I didn't realise you did that, Tom, you actually compared states against states and had the premiers against each other, which is fantastic. One of the things that may have...
He's making a pitch for competition payments, so incentive payments up front, not at the end of the 5-year accord period. So
one of the things that, if we're talking about
council CEOs, you would welcome that.
We would. We've been through that with Jeff Kennett. One of the things that big concern is actual the labour, getting the labour to do this and the skilled labour to do it. And then you've got states competing against each other. So Western Australia's got a scheme where they go saying build a life in Western Australia, and it's a $10,000 grant for tradies to go to Western Australia and live in Western Australia. So they've got nearly 1,000 people from other states have going there to do the construction in their particular state. Now that's fantastic for Western Australia, not too good for the rest of Australia, not too good for New South Wales when we're short of labour. So I think if the Commonwealth did something there around that time to somehow make we weren't competing against each other, and we're actually trying to meet a national accord which was set by the Commonwealth government, and that would certainly help us.
So.
It's a crisis without an emergency response. Like that's what it is. We live in this housing crisis. We know we need a lot more houses, but all these solutions are way out there, right? So if feasibilities on apartments are challenging, but greenfield's feasible and deliverable, then do everything you can to allow the market to deploy as much capital into that at that particular point in time.
So has the government put too much of its eggs in the density basket at the expense of greenfield, given that you've just said?
Well, the market is clearly saying yes to that. So, like, it's indisputable. The TOD delivery timeframes are well outside 5 years. Putting a 400-metre circle around the stations has also told every home owner in that location mentally that their properties are worth more, so it's taking longer to aggregate the land masses that you need to be able to get densities, and so it will take time to deliver that. The simple fact is we need more of everything. We need more apartments, more townhouses, more terraces, more single detached dwellings, and government policy should be agile enough to reflect where feasibilities are most favourable. And at this particular point in time, if you can't get the apartments built, you should lean into greenfield, which really means invest in enabling infrastructure.
Do you think there's an appreciation of that? You're saying that we can't get them built in time. Do you think there's an appreciation of that on policymakers?
I think the penny is starting to drop. You know, we hear, like I see Minister Scully say this on a regular basis. We've done LMR, we've done TODs, we've rezoned. Kirsten Fishburn says we've rezoned whatever thousands of hectares of land, but those things are not moving the dial today, and that's because I think they were a bit naive to the feasibility challenge, and they're starting to pivot and adjust for that. HDA is available, but there's no greenfield options available in HDA to facilitate planning proposals and rezonings. They say they're available, but nothing's got through the first gate. I think there might be the opportunity to kind of bring some of those forward. But I look at this and just go, every government crisis I was involved in, a bushfire, a flood, COVID, all of government deploys to meet that crisis. At the moment, that full deployment hasn't happened. And then the same thing exists if I was going to roll out, say, biodiversity certification, just using that as an example. At the moment, I've got little doubt that there's components of, you know, DQ, if that's whatever you want to call that long acronym with too many C's, E's and W's in it. But the biodiversity certification is stopping the ability to be able to maximise development in sites that have already been approved for development. That's not responding to a housing crisis. So at the moment, I think the big challenge that we've got is that we all know it's a crisis. I think we all accept it's a crisis, but we haven't fully deployed the emergency response to do that.
Tom? Oh, sorry.
I was going to say, I think that's right. There's not enough key players in the whole of government to lean in and start solving some of the
because the perception is the opposite. I mean, Judy's identified the issues in her electorate, peri-urban electorate, pressure for development, and she's outlined some of the more negative examples of.
But to Judy's point and what you're raising, or what you mentioned earlier, you know, right now, like the talking points for every federal politician will be to say there's $53 billion committed to solving the housing crisis. I can tell you $3 billion of that is allocated as incentive payments for meeting the housing accord. There's not one state that's within 100,000 of the housing accord. Rather than having that $3 billion sitting at the back end of a 5-year period, why don't we just bring it forward and spend it on infrastructure and Judy's electorate, so you don't have to pump out sewer, so you can actually flush the toilet and it goes to a water main. Or you can fund enabling water infrastructure or upgrade the intersection that's preventing a development from taking place. And before you even get me started thinking this is a greenfield only issue, if you think you can go and put all of the additional density into infill locations and not have to upgrade the 100-year-old clay pipes that is the bulk of the Sydney water system, it needs funding too.
For our three, I'll come back to you, Tom, but for our three chief executives of significant councils, do you get a sense that there's an appreciation of that last point that
No, there's not.
that Stuart made? Like there's certainly a lot of media commentary. That's the focus because that's where the infrastructure is. Almost an assumption that you increase the population there and you won't have to add to the infrastructure.
No, you look at.
In your interactions with the heads of government agencies, is the penny starting to drop that we'll have to visit these infrastructure issues in the TODs and non-TODs and the built-up areas?
Well, certainly the built-up areas, I need to look at it because Sydney Water just put in their IPART submission, and the IPART submission is the government's recommendation is it's going to be cut in half. And the view is that they don't need this money for the built-up areas. And then when you talk to the head people in Sydney Water, they say, well, that's fine. There'll be acknowledgement. We'll just tap into the existing system and we'll just have more sewer overflows because it can't cope. So we put more density in the infill and do the infills and that. We can't cope. The amount of money to retrofit that is multiplying factor compared to if you did this in the greenfield sites. So I don't think there's an appreciation of that. Certainly Sydney Water's making that point to the government and certainly not getting their their special rate variation through IPART will bring that up.
And it's not just water and sewer, it's roads. I mean, we all have a finite, in the brownfield area, we have a finite amount of roads. So, we can approve an extra, 2,500 dwellings in Parramatta and North Parramatta, but we've got the same amount of roads, same intersections, same number of traffic lights, same schools, same hospitals, same TAFE, same amount of everything, and no additional infrastructure investment.
The Sydney Water example is the single best example I think I could ever... I don't even think I could have come up with a better way to describe this. Inside the Sydney Water catchment or the Sydney Water servicing area...
You couldn't make this S up?
The target, the Housing Accord target is 265,000 homes. For the Housing Accord period, IPART is recommending that Sydney Water have enough capital investment to create 120,000 new homes. Like, that's their recommendation. They might be independent of government, but they're also independent of the housing crisis. Clearly, they don't think one exists.
So they tell me that...
The funding proposition is to say, it's all right, you just need to deliver 120,000 homes and you'll be fine. Don't worry about the fact that we've got this national crisis and we've worked really hard to work out how many homes. Sorry, you don't get a water connection. All you end up with then is Judy's problem.
And they tell me they're a business. They're not government, they're a business. And I told them if you were really a business, you'd be out of business because they cannot tell you exactly what you're going to get when you're going to get it. It's the most frustrating thing. But hopping away from water, if we actually had electrification of rail down into our area, or we had the Melbourne-Dumbarton completed, or those things, that would open up so much greenfield. Even if you can't give us the hospitals and schools, if we can hop on public transport and go somewhere, we can actually deliver more housing, but we don't even have the transport. You're literally dumping the houses out there with nothing. And that's the biggest frustration. If you give us sewer and you give us transport, yeah, we could do some housing.
Best lead-in for you, Tom, to offend lots of people.
Yeah, look, I would say that water is the most important thing, because one thing that no community is going to accept in the very long term is not having stormwater drainage, is not having potable water to drink, and is not having a sewer system to take your sewage away. So while roads is nice to have, I think it's nice to have, because frankly, a decent number of people now have the option of being able to work from home, have more flexible working arrangements. It's not perfect if the roads are congested, but you can now, COVID has demonstrated to us that we can adapt and change. You can't adapt and change to not having a water system. So I think that's really important. But I don't want to hang up...
I don't think he commutes. Just saying. I reckon this is the Tom Forrest version of Maslow's hierarchy of needs. All right, water is the precondition for life, and then you can have a road next. I'm on this team.
And one of the things that politicians often don't like is investing in water because there's no ribbon to cut. There's no fancy road to open. There's no physical asset to benefit from. It only comes years and years and years down the track when the development community comes out and builds it, and then the politicians don't get invited to those functions. Look, it does. I think it's really, really important. I was going to say when Stuart first said, "What is there a crisis?" but not realising it was a rhetorical question, I started scribbling down notes like, you should resign and. I said prices of new homes and existing homes are rocketing. Rental vacancy rates are catastrophically low. Rental prices are going up.
Is it the Productivity Commissioner's fault? I mean, he kicked this off several years ago.
In no small part.
Greenfield was too expensive. So fast forward to where we are today, the focus is on brownfield, TOD, that's no longer called brownfield, it's called TOD, HDA.
It's not the Productivity Commissioner's fault. The Productivity Commissioner identified that we could build more height and density around existing infrastructure, and that was certainly the case. We've had a bit of a battle with Ku-ring-gai Council, who at first tried to take the government to court over its TOD policy.
Did he not factor in, do some calculations projecting forward that if in 10 years' time an extra 100,000 in a whole range of LGAs in built-up areas, that wouldn't require infrastructure augmentation?
I reckon the presentation. Sorry, Tom. I reckon the presentation by a productivity commissioner goes to the cost to the taxpayer for delivering infrastructure per lot or per dwelling in an infill location is lower than what it is in a greenfield site. You roll that up to a premier and a treasurer, and it's like if you build 10,000 homes in this infill location, your infrastructure cost is going to be 80% of what it will be if you do the same 10,000 homes over here. On a kind of economic rationalist perspective, that's a pretty good piece of advice that you'd send to the government. But the moment you see the feasibility of this infill site, the cost to the consumer, the cost to build, being challenging on delivery, you need to adapt your policy, because all that's happened over the last 2 years is feasibilities have stopped the area where they were recommended to accelerate policy, and there's been no infrastructure in the greenfield sites. So the outcome is no homes. That's why we keep falling further behind. I come back to my point. You need more of everything. I think there's a little bit of an underlying sense in the government is that, yes, we want to say we're tackling the housing crisis and we think infill is more productive, but if you're not actually getting it, then it's not productive at all. You need to be able to turn on multiple fronts over a sustained period of time.
And the rules are an issue too, because it takes time to get any rezoning or development done, and it's not just local government, but it's the interpretation of the rules that come from federal, state and council. I've seen some examples where LEPs in one area right next door to another stop or start housing. And housing costs, let's face it, if 5 years ago the cost of a block of land to create a house was much different to what it is now. So every month that things sit in there, I think our wages go up 3% per annum and housing costs going up 4% per quarter. So every bit of time that takes time, and you're right about bringing that money forward, because it'll be much cheaper to deliver now than put that money in at the end.
Coming back to our topic, how can this be fixed? You're an MP representing an area that has these pressures. What would...
So in my particular area...
rezoning to reduce the uncertainty or the length of time or the complexity?
At the minute, we've got a SEP that sits over a 38-kilometre radius from the new airport that stops a granny flat. It stops people that live on 10 acres building a secondary dwelling. It has people that can build a 15-bedroom house on their 10 acres, but they can't build two-bedroom houses. These are people that already have their own sewer systems in place. The roads go past them. There's the opportunity to put housing there that would, yes, those people might make some money from it. The council might get some money, might be able to improve roads. So that's one of the issues we have, is these areas that are locked down. You know, they're locked down, they can't have a secondary dwelling because of the air flights, the flight paths, but they won't let them have insulation. They can't qualify for that. So that's one thing. When there's big developments, and forgive me, any developers in here, but they drip feed the development out. Let's have them, if they put a big development in, let's get all the development put out at once so that there is that larger number of houses. And let's have one set of rules. It's when you see, I've got some examples at the moment where a SEP says up to R4, but a council says the SEP overrides it in R5 and R5's not even mentioned in it. So, you know, we need one set of rules that are very clear so there's not this backwards and forwards and time taken.
I think the other thing that builds upon that, your point about SEPs is right. Nearly 40 years in local government, starting on a front counter in the Health and Building Department. And 40 years later, if someone asked me, Michael, can I build that granny flat in my backyard? You know, I can't tell you. It's probably going to take me 2 days to consult SEPs, LEPs.
Look at everybody.
All these other instruments.
Too many, too complex?
Yeah, to figure out, well, which pathway
You
could it
never
even
were
go?
a really good planner, mate. I can say that because I work with him.
I never argue with Gail.
Not one of my better students.
I never argue with Gail. I always come off second best. But the other thing too is what worked in our shire about it'd be about 12 or 13 years ago. The government of the day, which was the O'Farrell government, Brad Hazzard was the minister, and he said he came up with this scheme and said, look, we've got the appetite to look at landowner-initiated rezonings at no cost to government. So in other words, you had a way of dealing with the infrastructure it needed, the roads it needed and whatnot. So that produced a suburb in our shire called the Gables. And it worked. It gave they bought the land and became a single landowner. It's the only big single landowner release area we've got, as opposed to the fragmented stuff. They controlled the rollout of the infrastructure. They controlled the staging that it made sense. So we're not just doing a bit here, then someone's doing a bit there, and how do we get between the two? So it was all very logical. That's probably something to think about. But what I would say,
if you do that at a regional level, you need a coordination authority. I go back to the Olympic Coordination Authority, where councils had to get out of the way. And I'm not talking about giving up council planning powers. I'm just saying what Judy said, which is one set of coherent, consistent rules that are set by one entity, and if it's the feds funding it and providing the infrastructure, then good on them. And then we fall in behind because we know what's going to be delivered when, we know what the targets are, and there is one set of rules, not 128 across 128 different councils plus the state on top.
Look, what I would say in the Northwest, when we're looking at a proposal like that, the low-hanging fruit's just about gone. So when you start thinking about competing not just SEPs, but other legislative provisions like even the federal biodiversity legislation versus the state, when you start looking at that, it is the low-hanging fruit in our patch at least is gone. Everything else
across
is
the entire metropolitan area, it's gone. That's why they're heading down to Judy's patch, the peri-urban areas.
And I think there is a need. You would think that the what was that department with all the W's? You'd think that department would have a real. They would probably think they've got nothing to do with the housing supply crisis, but they actually do, because I actually think it's long overdue. When the growth centre in the hills was biodiversity certified, to switch off some of that legislation, that made it easier for assessments, and it made it easier for investment, and it made it easier for houses to be built. We're getting to a point where strategically we need to decide what sort of city this is in terms of a basin, and if ecology and biodiversity is important, we need to strategically manage that and then certify the areas where we want houses so that you switch some of this stuff off but still get the dividend of the environmental and the biodiversity dividend, rather than this piecemeal, hand-to-hand combat just about on every DA around ecology versus bushfire. We're going nowhere. So I think there's a big role for biodiversity certification in the area that we've got left to then unearth the areas that are developable and just let them get on with it.
Morris, I think that discussion almost highlights one of the problems and conundrums we face in the property development vis-a-vis planning, strategic planning space, and that is the competition between virtuous imperatives. There's no doubt that protecting the environment is a virtuous imperative. But then if we're going to grow the city, and we need to grow the city because we've got an ageing population and we need to grow the taxpayer base to pay for the unsuperannuated to have dignity in their ageing, which I assume most people think is a virtuous imperative, we have to grow the population to produce those taxation receipts. We need to house them somewhere. Competition between competing virtuous imperatives. So do we consider going greater height and density within those areas that have existing infrastructure? Do we consider going out further into the boundaries and extremities of the urban areas? Well, I think Stuart absolutely nailed it when he said we've got to do all of those things, because the numbers say at the moment we're delivering 45,000 homes a year, and an independent assessment undertaken by the Commonwealth says we need to deliver 1.2 million, which our share is 76,000 a year. We need to complete. Not just approve, complete. At the moment, we're completing in New South Wales about 45,000. So that's already added 30,000 to the next 4 years. So for the next 4 years, it's not 76,000 anymore. It's something closer to 90,000.
So when you say these things to bureaucrats that you meet, ministers, the two industry representatives, what response are you getting?
Oh, yes. you get, but it's exactly what was said earlier. We've already done the low and mid-rise housing reforms. We've done the TOD reforms, Tier 1 and Tier 2 TODs, accelerated precincts. We've done the Housing Delivery Authority. We've done infill affordable housing bonuses. What are you complaining about? Well, again, another competing virtuous imperative. They did the Tier 1 and Tier 2 TODs, and they did the infill affordable housing bonuses. And then they went and added affordable housing obligations. Now, when it was a percentage of affordable housing that was directly related to the uplift that you got in your land, and it applied for a 15-year period so that you could then, at the end of the 15 years, realise the capital gain that it helped pay for the affordable housing contribution, that is, the 25% discount to market rent for the 15 years that allowed you to supply those houses for key workers or for people in need. It worked. When it became 10, 12, and in some cases up to 18%, in perpetuity affordable housing. That is to say, you just handed 18% Macquarie Park, Crow's Nest, St Leonard's. It was part of the Tier 1 TOD accelerated precinct areas. The desire to address one imperative, the need for affordable housing, actually stops you providing any housing at all. So you actually exacerbate the first problem. If you don't make it feasible, by all means, if you make it feasible and you've got and you've done the FISO model and you've laid it out on the table and you've said this is how much gross revenue we think we're going to achieve over this. So these are the fees, taxes, and charges that you get paid. This was the cost of our land, and you can have a bit of an argy-bargy, which ICAC got in the way of a lot because they didn't want planners actually having a conversation with the property development community, but that seems to have eased off a bit. If you can have that conversation, you've got some chance of coming up with a solution, and that's what the Housing Delivery Authority has allowed. It's allowed the state government with professional planning assessors to get in there and have a discussion about what might be possible. What if we gave you an extra couple of floors? How much affordable housing could you provide? What if we relaxed the prohibition on casting a shadow over public open space in the winter solstice day by an extra 3 minutes? Could that give you an extra floor, which might allow you to deliver an extra 15 affordable houses? All of these things, that's the sort of argy-bargy that used to be the bread and butter of the planning community. It was taken away because it was considered to be corrupt. Now they've realised that just sending it away and having black and white rules really doesn't work for housing supply, and that's one of the reasons we're in the crisis position we are.
Are the states restricted just to that area, and you've honed in on affordable housing in perpetuity contributions, given the limitations with state budgets and also budget pressure on councils, and feasibility perhaps has surpassed approvals in terms of the key issue? The states can't control macroeconomic levers. State budgets are under enormous pressure, debt levels as well as the actual budget deficits. Beyond that issue that you honed in on, is there any other capacity for states to assist what Michael identified earlier on, perhaps in the opening discussion, I guess one also for Stuart, on feasibility? Daniel Mook is going to bring down a budget on Tuesday. He's not going to provide wholesale tax reductions to kick along the development industry. So, given the limitations of state governments in terms of their constitutional roles and their ability to influence economic forces, it's...
If I was going to be really cheeky, I'd say you've identified the TOD sites because there's all this infrastructure that's in place. You obviously don't need a contribution from the developers because that's why you chose the TOD site, because all the infrastructure's there. So you can turn that off for a period of 5 years to try and accelerate or make things more feasible. It's in line with the Housing Accord. I say that out of being a little bit cheeky because the whole reason why this exists is supposedly all of that infrastructure's there, so why do you need to charge the end user or the home buyer to do that? But look, I think the development industry generally recognises it's got to make a contribution. I don't think you can move the dial too much in that contribution space at the state level. I do get a little bit, I'm getting more and more uncomfortable about the size and scale of local contributions. I saw a contributions plan for Orchard Hills up in the Penrith LGA. It's $140,000 a lot. You're talking about that's the difference between a $1.2 million home and a $1.34 or $1.35 million home. I can tell you, That's the difference between getting a home loan and not getting a home loan, that $150,000 for a lot of people on dual income, median style incomes. So those numbers are really starting to have an impact. One thing I would absolutely do is I would establish, inside government there's things like regulatory impact statements. It shapes the way the public service think about decision making. Cabinet minutes have impact statements. I would create a housing impact statement for every single policy position. So every minute, every regulation, everything that was going to create that is a decision now, someone needs to actually go, what is the impact of this policy decision on the capacity to meet the housing accord target? Does it enable more houses or does it prevent more houses? And if the answer is it prevents more houses, then what is the justification for why we're doing that? You've got to bring forward, this whole idea of having a target is about changing behaviours, and you know the old management phrase, if it doesn't get measured, it doesn't get done. So I'd definitely do that. I think Tom is right around this cultural issue. If we had a health crisis, we'd bring all the doctors in and tell us what to do. If we had a crisis with crime, we'd bring all the police in and tell us what to do. If we had an emergency issue around flooding, we'd bring all the flood and emergency people in to tell us what to do. We've got a housing crisis, but we tell developers and builders and the people who actually have to build these things, sorry, we're not allowed to talk to you. Like, it's just absolutely crazy. There are really, really great planners in every local government area. There's great planners in the private sector. There's incredibly innovative builders and developers. Just let them do their job. Let them come up with the solutions for the parcel of land that's an obscure shape, that's got a park next to it, that needs to be able to create affordable housing. We need to let those people do their job again. And quite frankly, John Hatzister-Goss should put a big ICAC stamp that says this type of interaction and these engagements are not only come with our endorsement, but they are fundamental and a core part of good public policy making. And let's just be transparent about the discussion. Like, just tell people what the discussion was. The objective is still the same. Developers got to make some profit. We've got to get some houses. Councils have got to manage against the framework that they've got to do. So you've got to endorse that. And then I think for at least the period of the housing accord target, we have to invest more money. And even if it's debt financed, you must invest money in enabling infrastructure. And I think the consumer has to continue to pay. I'm sorry, but $1.60 a week is less than what in fact, if I didn't buy a coffee every day, I'd barely save $1.60 a day, right? Or $1.60 a week. That's the difference between IPART's recommendation on their funding versus what Sydney Water asks for. Right? I get that there's people that are under pricing pressure, but we've got to, if you want Sydney Water to function like a business, it's determined what the price of its goods and its services are, particularly for the purposes of delivering capital and maintenance improvements. So let them charge the price and let the consumer make behavioural decisions in order to regulate their usage. Like, we're just curtailing the experts being able to do the work that they're really good at. They're the three things I'd be doing.
So is the WIC Act used enough for water industry competition legislation for private solutions, where Sydney Water tells Judy, sorry, we can't service your small community?
Probably not, to be frank. And I think the scarcer the public dollar becomes, or the scarcer or the more under pressure the household budget is, the more you're going to have to augment infrastructure with public capital. I think those two things will sit side by side, and they'll continue to sit side by side. I suspect a little bit of politics will shape the comfortability of how much private capital can be deployed against particular forms of infrastructure, but when the choice becomes no infrastructure, I think you've got to let some private capital play.
So just I think there's two questions there. You know, housing shortage is one thing, but housing cost is a totally different issue as well. Even if you go back to high school economics with supply and demand and all the rest of it, they're two issues. But some of these developments that got put there, and you said no cost to government, we were sold Wilton at no cost to government. We were also sold one job every house. So those things, they've gone, but going into the future, we can't afford to keep allowing those sorts of things to be said and not delivered, like the Sydney Water thing. So, I mean, government's probably $2 billion behind in some of those smaller developments to deliver the sewer. to them. So how, how do we do that?
Right.
How do we catch up?
So just on a couple of points that Stuart made, 100% correct about ICAC. So ICAC rulings stopped the planners from talking to developers because there was corruption, and you couldn't do that, and you couldn't put frameworks around it. And in local government and in state government, and rightly so, corruption is something that we all want to stay away from. We don't want to have environments where we don't have that in place. You would get some fantastic results if your planners could talk to developers about the best outcome. So if we could do that, that would be good. If we got some sort of sign off by John Hetzig, or we've got some sort of sign off from the state government saying you can go and do that, that would be a fantastic thing. Regarding the contributions for council, I have a different view. Prices, there's been a cap of contributions over the years, prices haven't come down, so I don't think that's, I think from local government's perspective, I don't think that's an issue. The last one, Tom, for your conversation about affordable housing, I think we need affordable housing, and I think that we should make sure it's that it's feasible to do it, but also wouldn't it be great if we actually had key worker accommodation, so when you wanted to get skilled labour to come in, you could offer them cheaper rent to attract them to come to actually do the construction projects we need.
Yeah, and so there's two ways to do that. One is to tax the deliverers of the housing and therefore make it more unaffordable for everyone who's not got the benefit of being a key worker. So it makes it effectively you're taxing the 70% of the house in order to pay for the 30% or whatever the proportions are. Another would be to say, ease off on maybe some of the rules and guidelines that stop us delivering enough housing. Maybe some of the more affordable types are the south-facing apartments. Maybe they're the ones that don't get the requisite level of sunlight, but they're servicing shift workers who actually want darkness during the day and would prefer to have a south-facing apartment. Maybe that could be taken into account. Maybe not everyone wants the full amenity of the ADG and would be prepared to buy an affordable house in a location they like close to their job, but not get the full benefits of every aspect of the ADG. Maybe we're just being a little bit too precious about the sort of houses we think everyone must live in, and we could actually produce some cheap stuff that was right underneath the flight path that faced south and never got any light at all, but it's right next to my work and it's exactly what I want. Well, I think let people decide and stop treating them like mugs and treating them and saying you must live in the lifestyle that we've determined you shall live in. Maybe that's an approach to delivering more affordable housing.
The state government.
I'm setting Tom the Liberal Party membership.
Judy.
So the state government are doing some work. There's a release of the essential workers.
He wouldn't be the first to have two tickets.
And there's bills that are coming down that are addressing the change in affordable housing. Every time we see a developer, they say we're going to give you so much affordable housing, but there's work being done on what is really affordable and what the concessions will be. There's work on build to rent, build to buy. So they are looking at a range of things, and I think nothing should be off the table. I think, brown space, green space, whatever it is, we should have somebody looking at all of it. I think that's what it boils down to.
So is there any work going on, in a colourful way, Tom, address the issue of the ADG and ADGs, and is there, as part of this Accord and HDA and the TODs, is there any work going on, say in the planning bureaucracy or the housing bureaucracy about diversity of housing away from your two-bedder 85 to 90 square metre apartment that's fully 100% compliant with the ADG and has all of the amenity that Tom talked about? Is there...
One thing we should do with the ADG is make the G big and bold and underlined, exclamation mark. It's a guideline. Provide some flexibility. I think the ADG in many spaces has just become a set of rules that doesn't.
These three highly experienced, probably highest qualified executives in the local government system, could you actually sell that to your elected councils? I don't want you to make any comment about personal mayor or councillors, but given the makeup of your councils, is this something that you could, if you submitted a policy paper, would it ever get through?
Look, you could, Morris, because every local council thinks they know their local area, their local community the best, but we have a one-size-fits-all ADG guideline which applies across the metropolitan area. Everyone has to, it's a blanket approach. If you gave all of the planning directors the opportunity to write their own bespoke set of design guidelines, but they had to be less rigid than the ADG, they could come up with it. And I reckon you could have a good crack at getting your mayor and your councillors to agree to it, because you would have that local knowledge where you said, well, we might have a flight path, and I can't believe I'm saying that I actually agree with something that Tom said, but I do agree that there isn't that opportunity for that range of less amenable dwellings. And I'm not talking, don't go out of here and say Gail said ghettos are okay. But
that's what we're going to say, Gail.
Yeah, I know.
Ghettos are okay, Gail.
Yeah. But I've had councillors quoted with the ghetto line. Don't write it down, Tom.
New Telegraph League table.
But you're right. I remember being in the city of Sydney a lot of years ago, and there was a big argument about a 26 square metre studio and whether the council should be approving 26 square metre studios at the time, because everyone should be living in a one-bedroom apartment or two-bedroom, at least 80 square metres. At the end of the day, the council took the view that 26 square metres was okay because it wasn't provided anywhere else, and people who didn't want to live in 26 square metre apartments wouldn't buy them. So you can do it at a local level. You can have that flexibility. Not everyone needs a penthouse.
The Housing Commission did it 70 years ago.
Well, that's right.
Called them bedsits.
And you could have a federal housing authority that was in charge of accords and money, and they could set their own rules, and I'm sure people would live in those houses. But if you set the challenge to local planning directors at a local level, absolutely, that will come up with
you'd have to have
an
a fair
ADG.
amount of studio, micro apartment stock in.
Yeah, we do. So we had the light rail corridor came through two of our suburbs next to the University of New South Wales. We set aside 4,700 dwellings down in that particular spot, and 3,000 were taken up by student accommodation. 3,000. So it's virtually eating up all the housing stock that we had.
Why is that?
Because the SEPs made it more attractive for them to do that. They didn't provide car parking. They could get around some of the rules that the SEP allowed them to do that. So for the council, that wasn't their intention. The intention was to get more housing along that. We had great transport nodes there, but certainly, and the student accommodation should have been on the University of New South Wales land. They had land to do it, but instead of that, they've used the SEPs to get on there. So that's an issue certainly for us. Just back to your question, Ross, in the Great Republic of Randwick, my councillors would certainly be mature enough to have that conversation, to actually have the planning directors talk to, come up with something that's less onerous than the ADGs.
Whereas I sat on a panel yesterday up in Newcastle, and I was moderating a panel, and one of the panel participants said that the Australian dream around housing has moved from the quarter-acre block and a house to just a house, or just a home. It doesn't matter what it is. The Australian dream is having a home. If it's a two-bedroom apartment, if it's a studio, if it's a retirement village, if it's a house on a land lease community, if it's a house on a 400 square metre block, the dream is still having a home. The system's just not providing enough for them to be able to do it.
Just to take a Hills perspective on diversity, we've done it. So a diversity of product is essential, because if the only thing you can get is the small house on the small block, or the only thing you can get is the one better, well, the market will charge what the market will bear, and that's what it'll be. And if you don't have the diversity of the product, it doesn't keep the cheap stuff cheap, because there's no choice, right? So what we set about doing was saying, righto, because we argued against the ADG, and Tom, it was before your time, we were, as members of the Urban Task Force and UDIA, we were trying to get some traction around, well, look, we need to get this diversity of product, because if you're going to convince people to live in apartments, high-rise apartments in suburbia, they've got to be suitable for families, and we needed to have some bigger stuff with the little stuff. So we incentivised through FSR some of the bigger stuff, but you still could have the littler stuff. 1-bedders, 2-bedders, 3-bedders, and there's a graduating scale throughout. So we did have that conversation with the council, and we did win that. They were always starting at the bigger apartments, but we've come back.
So is there any opportunity being presented to you, all of you, two industry bodies, an elected MP, to channel this into all the work that's going on? When we hear that there's a review of the Planning Act, there are these discrete planning pathways that have been established, in whatever conversations are occurring, probity allowing, Is there an opportunity that is being presented to channel these? Because what I'm hearing is that contrary to the perception, contrary to the myth that you'd never carry the day through local government, your elected part or the administrative part, the three of the biggest councils in the state are here saying, well, my council's up for the conversation. We've had a past conversation. Is there, I'll start with the two industry bodies, I guess, because you're probably, in a professional sense, either your individual members or yourselves in structured meetings with ministers. Is there any opportunity to channel this into, say, a review of, it's not the Planning Act, but it's something that's pretty important that sits in parallel to it? There's these conversations about streamlining the way that housing is assessed and delivered.
Well, a couple of questions there, but in relation to general guidelines for the production of housing, they are becoming, the overwhelming trend is, while there are anomalies, and while I completely accept that if you gave the council staff the agency to be able to work together and come up with an alternative plan with those targets in mind. So they've got targets and they've got free agency to come around with acceptable options that they could present to the councillors. And I accept that that's the case, but by and large, I think at the state planning level, we've not seen a push towards that from either the former government or the current government. There was a desire at one point to introduce the design and place SEP, which would have added additional controls and that was reversed or not progressed in total by a subsequent Liberal Party planning minister. So you had a bit of a debate going on there. I got personally lambasted for opposing quality design, for opposing, when we weren't, what I was trying to push for was more affordable houses in the context of a housing supply crisis. I say, do we really need to increase the separations between the tall buildings, therefore getting less homes in the same space? If you've got public open space within 400 metres of that location, do you really need to have the increased separation and the increased light, etc.? That was just one example. Do you really need the level of deep soil plantings? Because in the context of apartments, for example, if you've got limitations on where land is set aside for deep soil planting, that means you don't get the underground basement car park across the full area of your land. It means you've got to add an extra floor for that underground parking, because that may well be mandated by the local DCP, Development Control Plan. You add an extra floor to your parking, you've just added $60,000 to every home in that development, in a typical development. So there are real trade-offs between something that you might like to have because it's for a better design, and this is sort of the wave of upper middle class indignation from the North Shore, telling the people of Western Sydney how they should live, but then making it so unaffordable for them to live that way that no houses get built. That's a problem.
Well, it's a problem when we read in the paper that the way to get houses built is that house prices have got to go up. Mm. So I read an article that said, well, until house prices come up, we're not building any houses. So I kind of think the answer's got to be a better alignment of supply and demand, in my view, and the choice of product. And it can be done. The
financiers won't give you the money to build the house unless they can see a profit at the end of it. They just won't.
That's right.
Unless they can see that you're going to make money out of building a house, they won't allow you to start construction. It's
but they're more likely to if you pick up what Michael said.
Yeah.
And you implement that, then the financiers, surely the banks and
if you get a better alignment,
the non-bank financial institutions will be more likely to lend.
And some councils might be ready to listen to those ideas, but I would tell you my councils are not ready to listen to those ideals. At the minute, we've got an area right next to our railway station that could have had the first units, 1-bedroom studio, 1 2-bedroom apartments on, and we're getting a flat Coles with nothing right next to the railway station, simply because they say until we get electrification, we're not going to have any high rise. And it may only have needed to be 2 or 3, but we could have delivered an area, some of that different diversity of housing, but they're not ready for it. They're still after the large blocks and the large whatever.
Yeah, it is, and that's certainly been a journey in the northwest as well.
Yes.
So it didn't happen overnight. But one thing I would say, if we're looking for our state friends to contribute, We have 2 TOD areas spanning suburbs. You'll probably hear them in the news, Kellyville and Bella Vista. Was already zoned in 2019 for 8,000 odd apartments. The government bought that land when it was basically rural land values. So it doesn't owe them much, right? Guess how many houses have been built in that precinct since it was approved? 0. So there could be, if there is a real crisis, there could be 8,000 government-funded homes while the feasibility improves in that precinct alone. And now it's 12,000. So, okay, in the fullness of time, we're sitting there doing nothing.
So is that under Landcom ownership, is it?
It is. It is. So most of that TOD precinct is Landcom owned, and the model is packaging it up and selling it off at a time when the market can give it a price. So someone in Treasury is telling them to give them a dividend, so they're doing their job, but equally, not one house in zoned, serviced, TOD land, 8,000 homes, not one house built.
Next to trains.
I think there's a real opportunity to, I'll say, reframe what the focus of and responsibility or role of Landcom is. But I say reframe with kind of my tongue planted in my cheek, because I think it's almost just take Landcom back to what its real job is. I think there's great opportunity to use Landcom as a lead developer, to kind of be the arrowhead to pull through the private sector. When we talk about diversity of housing stock, it's not just in apartments, it's also in detached or semi-detached dwellings. We want people to be on smaller parcels of land. We want to have smaller homes, less energy intensive, better delivery for infrastructure costs. You're going to see that diversity moving across greenfield sites. To make that happen, someone's got to take some risk. And I think Landcom's well placed to take that risk, show that a terrace, a design of terrace homes could work in a greenfield setting in Camden or Campbelltown or the southern part of Penrith or even parts of the northwest. But at the moment, to kind of take that to the bank and say you're going to be able to deliver that product and someone's going to buy it, that's a hard sell. But I think Landcom can take that risk. On sites like what we've just heard there, you know, maybe Landcom has to do the first delivery, and then the private sector comes in to do, you know, stages 2, 3 and 4. But I think we've got to reshape the use of Landcom to become a bit more of a risk taker, to be able to proof up that there is a return there. That will help banks get more comfortable with pricing structures. That means, unfortunately, in some cases, you might pay more for a property, but a property's getting built. At the moment, if the bank doesn't think you're going to make a margin, it's not going to give you the money to fund the project.
Landcom used to do a really good job in Western Sydney.
Greenfields.
And Greenfields, where they would pretty much lead the market around, certainly in the northwest.
So what's holding them back from doing a really good job again in either
Well, to go back to your earlier question, Morris, is there a pathway for all of us to work together? Yes, in the old days, I remember being on a ministerial task force. I think you were Premier, you set it up. I think Gabriel Kibble chaired it, you know, reform of developer contributions. There was one for something else. It had industry on it, it had local government on it, it had state government agencies on it, it had lobby groups on it, etc., etc. Everyone came around the table with a common purpose, which was to sort out whatever it was. In my case, it was developer contributions. And there was reforms recommended to Cabinet, and they got up. Yeah, the Department of Planning has made a really good start with a lot of reforms. Are they cracking the problem? No, they're not. What else needs to be done? I think there's really good ideas from industry, there's really good ideas from local government that can help, really good ideas from lobby groups and some agencies. Get the ministerial task force in the room, because we've all got ideas that we can contribute, but there isn't the forum at the moment. There isn't the forum.
Conscious of time, and there's two very quick topics I wanted to cover. And we'll be in reverse order. This was going to be the end, but I'll ask this question and very quickly, because we've got, let's say, 3 experienced, long-standing chief executives, 2 lobby groups, industry groups, and the perspective of a backbencher. Premier and Leader of the Opposition are in discussions, I think negotiations. He said that one of the big next steps is a review of the Planning Act, a very quick one. not a wholesale review, should take many years, but looking for what are practical, relatively quick measures. If you were part of such a task force or group, 3 areas or 3 ideas for the Premier in his discussions with the opposition and the crossbenchers as to what changes would make the Planning Act work better to help address 3 or 1, whatever.
A much greater emphasis on strategic planning and engaging the community as early as possible at the strategic level, and reduce the community's engagement at the project level. So a much greater emphasis at the strategic level, and be really disciplined about the regularity in which you revisit that strategic planning, so the community has a clear buy-in. And then the second thing I would do is I would augment the planning pathway. So we could talk about complying development code. I'd make an adjustment that was kind of a hybrid model that allowed, if you had if you had a building that was 90% code compliant and there was 10% of the building that was outside of, just assess the 10% in a hybrid framework, so you didn't have to open up the entire project for contestability. And then probably the third bit, more along the lines of merit, but I think we should think, rather than it just being about merit, what's the impact on the community? Assess the impact, solve for the impact solution. I'd be looking to do that. But actually, I've got 3. My third piece of advice is, don't stop with a light touch change. Blow up the whole thing at the start of the next term, whoever wins, and rewrite the Planning Act for the 21st century, or the century that we actually live in, with the challenges that we occupy, with the need to balance housing and environment, and a practical reality around the economic benefits and cost of delivering housing, because that's not what we have at the moment.
Michael.
I think very quickly, and I agree with some of what Stuart just said. First of all, I think a modern Planning Act wouldn't have so many different pathways for an approval. There just should be a lack of steps. There should be just one version of the truth. Heaven help us, the LEP is controlled through a template anyway. So we should be able to get to one version of the truth. I think the second thing is, I would sort of try and pitch a approval pathway that deals with merit, that sits somewhere between the CDC and a local DA. I think when you look at an exempt, complying and development, when it goes, if I pick a simple structure so everyone can understand what I'm talking about, a deck at 10 square metres might be exempt, at 15 it might be complying, and at 16 it's a full-blown DA with all the consultants' reports and whatnot. That happens in housing too and other developments. So I think a more streamlined, almost
assess the impact of the 1 extra metre.
Yeah, building permission as distinct from a full-blown DA. I think there's too much cost in putting a DA together these days. I think the other point you made earlier about empowerment, to be actually able to tell the customer, build it this way and you're going to get an approval, I think that should be all right. You know, if you want to go and build it some other way, we'll have an argument about it. It'll take a bit longer. I think they would be some very, very good steps, and I also think they've got to address the inherent conflicts in the assessment criteria. You can't go back to the bushfire diversity, you can't solve both satisfactorily. Something's got to give, and at the moment, everything has to be solved.
Go.
I would go back to 30 years ago when he was working the front counter.
I didn't want to go back to the future.
But it was simpler, and 2 things. Yes, the strategic planning needs to be done up front. You got a pink zone on a map. It said residential, you're allowed to build houses. Planners didn't get involved. Didn't need a DA to build a house, right? So when you were working the counter, you put in a BA, a building application, because the resident expectation was if you lived in a residentially zoned area, you're going to have houses around you.
Who would have thought?
Right? Who would have thought, right? So why the hell you need a DA to build a house is beyond me, because the sky didn't fall. 30 years ago, everyone looks at those dwellings now and goes, oh, I wish there was more like that. They had backyards and they had front setbacks and they had all of this, all right? No DA required. That's why they worked. And then it got more and more complicated after that. So let's go back to when you were working the counter and someone came in with a BA because the strategic planning work was done up front and the council said you can build houses here, you can have a school over there and you can have a park over there, and it worked. We've got to go back to that.
Can I just chalk that up to Gail actually...
Imagine trying to do that.
Gail actually agrees with me.
Yeah.
Can I just chalk that up?
I didn't hear that.
Gail actually agrees with me on that.
I seriously, when I was a DA jockey, I had people put in objections to houses in residential areas because their dog wouldn't like it. Tell me that we haven't gone crazy in that space. Seriously.
Right.
Rip it up. It's a document that says not to do planning, not to actually grow New South Wales. It's incumbent upon developers to just get many reports to say why you can't do things. So just simplify the thing, rip it up and start again. Because all we're doing with all these suggestions here is just adding to the current problems.
Gee.
I'll be very brief. Agree with everything you're saying. A clear set of rules, one clear set of rules, not something that can be interpreted differently. I'd like to see the allowance of secondary dwellings on larger blocks of land. I'd like to see mass release instead of drip feed of developers' buildings, and infrastructure in place such as sewer and transport, and then you can go as wide as you like.
Mr Forrest, you've got the last word.
I'd like to say rip it up, but I think having had some experience in some disappointing as well as positive experiences in politics, I'd say if we tried to come up with a new planning act now, and then we took it through not only the debates within the lower house, but more importantly, we tried to take it through the upper house. And you had Mark Latham and the Greens and the Animal Justice Party and all of the other groups. Goodness knows what you would come out with is your planning act at the end of that. And frankly, that would be a lottery I don't think we can afford. So I start with a practical and simple amendment which could get bipartisan support, I think, and it well might. I'd start with making housing supply that meets demand an object of the EPNA Act. At the moment, believe it or not, it's not. It's not. So I'd start with that. And I would also give that object of the Act primacy over other objects. So the courts and the decision makers and the councils and the panels would be required to ask themselves the questions that you've heard so many times around this discussion. Does this improve the likelihood that we're going to get housing supply or not? Or does it make it worse? And yes, if it does make it a bit worse, but it's against the catastrophe of climate change, or if it's against flood impacts, or it's against a massive overshadowing of a public open park, then of course you can justify that you're going to limit that development. But nonetheless, it puts front and centre the idea that we're going to deliver enough houses to meet demand. Who knew?
Thank you.
That's only one. Planning proposals should have. Planning proposals, Morris. Planning proposals should only assess strategic merit. Development applications should address site-specific merit. If you've got, unless you're doing something way outside what your strategically approved planning proposal says, you should pretty much automatically get a pathway through referrals and concurrences, and you should be allowed to appeal stupid panel decisions to a court or to the IPC, because too often we get stupid panel decisions.
Thank you. Thank you to everyone. The question that I'm not going to ask, that I wanted to, was of our three local government representatives, and it was, the question was going to be, and this will be for another time, what demographic changes are you seeing in your three areas as a result of housing supply crisis and government policy announcements on TODs and HDA with the arrival of metros and light rails, but that will be for another time, because the federal election just passed showed some fascinating data on what's occurring, and I was hoping you might share it, but we've run out of time, so your next conference next year.
Morris, Stuart, Michael, Gail, Ray, Judy and Tom, on behalf of everyone here, I would like to thank you for sharing your enormous wealth of experience and knowledge in creating such an interesting and enjoyable discussion. Thank you for the panel. And that does bring us to the end of the formal part of the day. I'd like to thank you all. Thank you for participating and being present throughout the whole of the afternoon. I know it is difficult, particularly on a Friday afternoon on occasions, but we do believe that that must be a testament to our speakers, and we thank you for staying and enjoying them. We trust that you enjoyed the afternoon, that you gained some value from it. We do have a survey you might have seen in the package, and we would really appreciate if you could fill out that survey and leave it with us. And now, if you would like to join us for drinks, we'd really appreciate it. Thank you.
Yeah, I know. Yeah. I'm really pleased to hear that. She's,
It's on loud now.